it has also been informed that respondent number so-and-so Bolai Mia has passed away. And in this regard, a photocopy of the death certificate has been furnished to the learned PP who has appeared online. As regards Asik Ali and Abdul so-and-so, appellant number so-and-so, they have been reported to be absconding. Para. This court had held a hearing on the aspect of sentencing, wherein appellant number so-and-so Moinuddin had said that he has nothing to submit, full stop. Be that as it may, and in the interest of justice, a further chance is given to the appellant Moinuddin to respond on the present aspect of sentence hearing. Full stop. I list this case for consideration on days 17th. 24th. Please ask him. 24th, 3. By the next date, it is also directed that the original death certificate, so far as appellant Bolai Mai is concerned, be furnished to the learned PP at Karimganj. The officers of the concerned police station are to submit fresh report regarding the absconding appellants Asik Ali and Abdul so-and-so by the next date. We'll have it on 24/3. Okay. Till the next date, Moinuddin, appellant Moinuddin, respondent number so-and-so Moinuddin is to be kept in custody. Okay. 24th.
चौबीस तारीखे आपने अपने उकील
Yes, brother, you may pronounce. You're not audible. You're not audible.
Call somebody.
There is no voice.
It's not audible.
Yes, now it's coming.
For reasons mentioned in the judgment, the appeal is allowed. The appellant, Hajrat Ali, is acquitted of charges, giving him benefit of doubt. He is directed to be released from custody forthwith unless he is required in connection with any other case.
Okay.
Last hearing, man.
Okay,
Talk to matter, man.
Mubin Marak.
Yes, man.
What is your prayer? There is a private respondent.
Private respondent, man. And already they have appeared, man. But
Name,
no
name?
name is not shown. Last occasion
Who
was
has appeared?
is the
Eight, sir.
order dated 5/8/2024, man.
Oh,
5/8. Last order.
though this appeal has been listed for hearing, the name of the learned counsel for the respondent number 2 has not been reflected
Yes, man.
in the cause list. Full stop. Registry to verify and reflect the name of the learned counsel for the respondent number 2 in the cause list, and thereafter, and list this matter for hearing.
I am obliged.
May it please the Lordship. Lordship, I beg to mention item number 10, Lord.
Yes.
Kindly adjourn the matter for the day. The senior is out of place.
There are other 10 is connected.
Yes, Lordship.
Which
I have
is
informed the respondent number.
Okay. on a prayer made on behalf of the applicant. Respondent number two,
Yes, sir. I have informed. the respondent.
applicant, on the behalf of the applicant, matter is adjourned to be listed after 1 week,
Yes, sir.
after a week. Miss, A. Begum Leonard APP is present. You are also there,
Informed.
informant. Andeka,
And
N. Chaudhary, Miss N. Chaudhary, legal aid counsel. Miss N. Chaudhary, Leonard, counsel for respondent two, Do tally,
like,
Item one.
item 1 to 3, jail appeals.
One is 302. I don't think I've been those, please, huh?
Notice not required.
Oh. This is an appeal preferred from jail under so-and-so, against so-and-so. Admit, call for the records. Miss Ed Jahan, Leonard, APP, is present for the state. For her. List of 6 weeks, along with service report, along with report on receipt of records. Since working appeal list from jail, we appoint 32. Anup Rinal Datta, amicus. Name to be reflected. একই ধৰণৰ আৰু।
Item two.
পক্সো। পক্সো।
Oh. Then to note.
পক্সো হলে এইটো পঞ্চায়ত আন্ডাৰ in a manner prescribed from the through the registry, by the registry, through the office of the so-and-so. আৰু পক্সো serial number 16, Vipul Bhagavati. The last of 6 weeks for receipt of records as well as for service report. Okay.
Three.
Pokso. Pokso. Same. Serial number 15, Nabo Kumar Kulita. Steps for it to respond to 2 neleki baha jail as to victim oblique informant ho. Anete memo appeal kuna city akona.
Item four.
Yes.
This is a conviction period for 20 years.
Pokso.
Yes,
Will admit this.
6 of POCSO and 376 of
Yes.
API.
Hard free so-and-so learned counsel. First preferred this appeal under so-and-so and so-and-so. Admit. Call for the records. Miss A. Begum learned so-and-so. Respond number 1. Steps for respond number 2. To be routed through the office of the POCSO. After 6 weeks. Yes,
One I application.
application.
Kindly state
Notice.
a input order.
Well,
He may be released on previous building. Because
POCSO, how do you release him?
what happened?
No, we are issuing notice. 6 weeks.
For RA, section after
6 weeks. Hurricanely 6 weeks. In the meantime, objections may be filed.
Item 5.
Paperwork is ready, Lord,
Item 5. GL appeal.
Lordship. Lordship, Lordship. Software.
Both are waiting.
How was it sent? Through the court or through you?
Lordship, as it is a jail appeal, it is sent to registry, Lord.
No, no, it
So
has to be
exile,
routed.
it
It has
can
to be
go
routed.
through us, but
It doesn't appear so. If it is through you, you can directly take the
Lord
information.
instruction, Lord.
Okay. But you can still take the instruction
Lord,
because it was issued.
Lordship,
Okay.
I will take the instruction.
Okay. This appeal was admitted by the order dated 5/12/2022, and in the meantime, paper book is ready. Full stop. However, there is no certainty on the service upon the respondent number 2. Full stop. Office note dated 11/3/2025 depicts that service report has not been received. Full stop. Para. Since the conviction involves the POCSO Act, we direct Ms. A. Begum, the learned APP, to obtain instructions from the concerned Manikpur Police Station on the aspect of service of notice upon the respondent number 2. Full stop. List after 2 weeks.
Three.
2 weeks. You send a W.
Last, next, Lordship,
Okay.
Lord.
2 weeks. Approximately, none appears for the appellant on call, whereas Ms. A. Begum, learned APP, is present. Yes, next.
Item 6.
Service is complete, Lordship, and paper book is also ready. 6.
Madam Sultana, where are you? You are there.
My
in
lord. Paper book is ready, my lord.
Sir.
And service is complete, my lord. My lord, with
Right.
IA maybe is set for hearing,
It,
Which I-
it involves POCSO
not under section 302, my.
302. Okay. Now, paper book is there. We can have this for hearing.
Yes,
Lord.
my hearing, my.
Okay.
And kindly make that maybe fix, my.
Heard Ms. B.R.A. Sultana, learned counsel for the appellant, as well as Ms. A. Begum, learned APP Assam. Also peruse, footstep, also peruse the office note, not office note, order dated 4/2/2025 passed by the learned Law Jima Court on the aspect of service upon the respondent number 2. Full stop. The same is accepted. Para. As the paper book has already been prepared, list the appeal for hearing. When? In the first week of May.
First week of May.
Okay.
Possibly with the IA, my lord.
We'll have, we are hearing, we
Yes.
hear the entire appeal. I is kept alive. Tip ಮಾಡಿ ಬಾ ಅದು transparent tip into.
Item
Mr.
7.
Bakshi, where are you? Your matter was there. You come after the matter. Should have somebody উপর to কাটি দিব, not appears to কাটি দিব.
My lord, I have received your paper book.
We know, we passed the order, check the order.
Yeah.
এখনই লিখবো উপর, non-appeal, appeal এখনই লিখবো।
Quickly only. My lord, I have received the paper book. And my lord, conviction here is 302 months. So I think, my lord, the respondent number 2 cannot request.
Yes, sir.
Sure, sir. So maybe stand for hearing.
Oh. This is 302, the respondent to, appearance is not mandatory unless it is possible. So we have it for hearing. This appeal was admitted on 3/5/2023. Full stop. Full stop. And records are called for. Okay, full stop. The paper book has also been prepared. Full stop. Though the office note dated 7/3/2025 depicts that there is no certainty on the aspect of service of notice upon the respondent number 2, comma, since the conviction is taking into account the nature of conviction, the presence of the respondent number 2 is not mandatory. Para? As the paper book is prepared, list this appeal for hearing in the second week of May 2025. Means A Begum लिखिएगा। Ganguly, what is it?
Last order shows lordship with the Ozima court. The steps were not taken. The steps were subsequently taken on 4/11/25, lordship.
You're against the conviction,
No order of acquittal.
or you're challenging the acquittal?
Yes. Another report has come from the learned session judge that the convicted person, they have also filed one criminal appeal, and lower court records have come in
Few of them have been convicted, few have been
acquitted.
acquitted
Yes.
against the acquittal year before us.
Yes,
And against those conviction orders, they have come.
yes.
So
Lower court records have already been received in respect of those convicted accused persons. That is there in the order I have
here
found.
are they served? Have they been served?
That I could not find, lordship.
A letter has been received, the urgent case records, that is okay, case records. What about service? You have not even taken steps?
No, steps have been taken later, lordship, on
When?
4th of November.
Huh?
I have even checked the official website of the High Court.
But
In that column, official Talabana is shown to have been received by the registry on 4th of November, 4/11/25. Perhaps it is-
4/11.
Yes,
This is an order of 3010.
10.
3010 says you may not be even
Yes.
interested.
No. Thereafter,
4/11, where is it?
that I could not find.
Okay. Peruse the office note dated 11/3/2025, as per which the records have already been transmitted to this court in connection with criminal appeal 113 of 2024. Full stop. Para. 3. A. Ganguly, learned counsel for the appellant who has preferred this appeal against the order of acquittal, has submitted that the said criminal appeal 113 of 2024 has been preferred by few of the convicted persons. Para, as regards the office note dated As regards the order dated 30/10/2024, passed by the learned Lozima Court, comma, Sri Ganguly, the learned council, has submitted that on
4th of November.
4/11/2024, steps were taken for service of notice upon the respond numbers 2, 3, 4, and 5. Full stop. Para. Office is directed to verify and put a note on the aspect of service upon the said respondents. Para. List after 3 weeks.
Both the cases may be taken.
But hearing will be different. Records will be, yours should
But
be
arising
entered.
out of the same case.
If you are on the same side, then one hearing, but you are against the acquittal. Even if the records are there, hearing cannot be an analogous hearing. Okay,
Okay.
let us not pass any orders.
Yep.
Both the appeals are going for against conviction. One hearing. No, he is completely the opposite.
May I please your lordship?
Yes,
It's a bail matter lordship. It's filed under section 21(4) of
Yes.
NIA Act
yes.
against order dated 7/10/24 passed by the special judge. NIA.
So it was admitted. You want to press this today?
But I have filed my objection. What's happening?
If you want to press this, we can. It's only a bail, nothing to do with paper
Yes,
book.
lordship.
We can-
Lordship, their date of arrest was on 15/9/22. So 2 years, 6 months behind the bar, lordship. And the co-accused in this case are already been granted bail. All the co-accused.
Just a minute, please. Objection is on record.
Yes. Happened, right?
What is the stage of the trial?
It's an evidence, your lordship, 12 PWs are examined out of 111.
We can consider now, if you're agreeing.
Lordship,
Are you ready for the matter? Or
in fact, Lordship, I would have, but
we can have it tomorrow or on Thursday?
if it is on Thursday, it's
Thursday. But Thursday we'll finally consider.
Okay.
This side or that side, we'll
Yes.
consider. No point hanging
yes,
this
yes.
Lordship.
Thursday, madam. What is your name, madam?
G. Deka, Gitanjali Deka.
Hart, Miss G. Decker, learned counsel for the appellant, as well as Sri R.K.D. Chaudhary. Your SC NIA?
Yes.
SC NIA.
Yes.
Para? The records, I say? Para? Pursuant to the order dated 4/12/2024, the records have also been received. Para? Considering that this appeal is against rejection of a bail application, comma, list the same for hearing on Thursday, huh?
All right.
On 20, madam, 20.
Lordship, on the last occasion, the trial court records were called for. Regarding that, letter from the Sessions Judge South Formalizing received that the original case record of Sessions case number 1821 has already been submitted to the office in letter dated 233J in connection with criminal appeal number 44220.
Hmm,
So the record must be here on the record. So the paper book will be
yes. What is your name?
MS Singh
M.S. Hussain,
on behalf of Aon.
Hart, 3 M.S. Hussain, learned counsel, appearing on instruction of 3 A.M. Bora, learned senior counsel for the appellants, who has referred to the office note dated 20/2/2025, Para, peruse the same, as per which the TCR has already been transmitted in connection with Preliminary Appeal 442 of 2024. Para, office to verify the stage of preparation of the paper book. Full stop. List after the paper book is prepared. Ms. A. Begum, huh? Present. Yeah, Mr. Dhar.
Regarding item 12, versus S. Jahan, there is some instruction for mental health report, I have.
Yeah.
So Lordship, she will
last
be there
petition.
after.
Wait for a while, let her come.
Please,
But-
It will lost, my lord.
Yes, Mr. Sharma.
By order dated 28/2/2025, my lord, and the health report was called for.
Report is there, Lord.
The report has come, my lord. Because he wants a ailment for treatment. He's got severe tuberculosis, my lord, and lungs are in the stage of damage. Well, in that affair, he needs well, my lord. With any condition, even if a lordship wants to fix some date by which he should surrender after treatment, that also he will comply. Because he is sent to medical college, my lord. Medical college, usually a TB takes only 6 months to be fully cured. But here, my lord, it is about 8 months since he's not getting better, but his condition is worsening.
But he's already been treated in the LGB chest hospital.
My lord,
He's already been treated in the LGB chest hospital. He's already been treated. He's getting treatment.
Yes.
Presently, he's admitted in our hospital.
yes. But my lord, their treatment, he is not improving. Rather, it is bad to worse. For a limited period, even, my lord, subject to,
Now, where do you want to see? It is only for the purpose of better treatment,
yes,
for which you are seeking bail. Where do you want to treat him?
or in private hospital, my lord.
For TB?
Lungs is, my lord, on the stage of death.
For tuberculosis, you have to. There are designated hospital which are specialist hospital. This chest hospital, LGB chest hospital, is a designated special hospital. That is perhaps one of the best in this for this disease. Madam, what do you say?
Going on, Lordship.
No, that his
for better
contention is
treatment.
a reasonable one.
Yeah, that is.
It is only for the purpose of better treatment.
Better
Now,
Yes.
is it possible for him to have better treatment in any hospital, private hospital for tuberculosis? We don't think so. Had it been say, any other disease, tuberculosis
So outside, somebody they may not allow,
outside of is
not possible. That's why, my lord, in any hospital, private hospital.
See, the jail authorities had into the option GMCH as well as this LGB chest hospital. LGB chest hospital is special only for
Yes, I know.
tuberculosis.
But one, yeah, after it is government hospital, my lord, or whatever it is.
But the paper book is prepared.
Yes,
We
ready.
can have this for hearing. How many appellants? How many appellants? How many appellants?
No, mainly, my lord, girls too.
One, Lord.
Only
One appellant. We can have this for hearing. Paper book is there.
Yes.
Instead of this conviction under what section?
Section 6, Foxtrot.
POXO. How many witnesses?
Witness one, sir.
Lordship, 12, 8 witnesses,
Eight
PWs, Lordship, 8 PWs. 1 CW.
APW won't need much time. We can have it.
Mainly, it is the instrumental victim. Otherwise, apparently, it is very serious case. A girl of 17 and nearing 18 was, she had physical relation with 3 boys at a night, 9 times. And FIR was filed by one of her friends.
Okay, we'll we'll have the main appeal for hearing. Okay. And in the meantime, you continue with the treatment. He appears to be in the hospital.
Sure.
Okay. Heard R.P. Sharma, Learned Senior Counsel, assisted by Ms. Sum for the appellant. Also heard Ms. A. Begum, Learned APP Assam. Para. The Learned APP has produced before us the status report on the health of the applicant full stop. The applicant has been diagnosed to be suffering from pulmonary tuberculosis and is presently admitted in the LGB chest hospital. Full stop. Though the Learned Senior Counsel has submitted that the health condition is not improving and the appellant and the family members of the appellant desires for his treatment in any other hospital, we are of the opinion that the LGB chest hospital is a special hospital for the kind of disease presently suffered, which the applicant is suffering. In any case, it is seen that the paper book has already been prepared
Service.
and service has also, service is also. Where? You have
No.
not taken steps.
Second, Lordship, there's a report.
Has already been
Okay.
all prepared, full stop. As regards the aspect of service, though there is an office note dated 12/3/2025 that no steps have been taken, Ms. Begum, the Learned APP, has submitted that the conviction being under the POXO Act, that the conviction involving the POXO Act, steps were taken through the office of the PP Assam for service of notice upon the respondent number 2, which was accordingly done. She has also produced the relevant communications. Give a copy. Exchanged with the concerned KPS, concerned Potasil Ambari PS police station, which have been produced. Para. As the respondent number 2 has chosen not to appear, we appoint the Vikas Prasad, serial number 12, to act as the amicus curiae on behalf of the respondent number 2. Para. Let a copy of the paper book be furnished to the learned amicus curiae, and the appeal be listed for hearing in the second week of May 2020.
Can you read early, my lord, in April?
April, the mid of April is holidays. In the first week of May 2025. The name of the learned amicus curiae be reflected in the cause list.
That may be, my lord.
We said first week of May, we'll have it on 6th of May. Is it okay? Tuesday.
Yeah.
6th of May, okay. We'll return the originals, huh?
Lord.
Copies of the communications exchanged by the exchange with regard to the service upon the respondent to are made part of the records. এখানে photocopy করুন।
One observation I want that let him continue with the LLC. Yes. Well,
The
Yeah.
the
tell he recovered.
and he's already in treatment. Yes.
Just a lot.
It is needless to state that the treatment of the appellant be continued as per the advice of the doctors.
Okay.
এখানে হলে কি ওইটা একটু হেরে এটা মেডিকেল item
14, Lord Chief. I have filed this IF for condemning the delay of 14 days.
matrimonial appeal.
Yes,
You are Yanthan.
yes, Lord.
Heard Miss Sunsu Yanthan, learned counsel for the applicant who has filed this application under section 5 of the Limitation Act 1963 for condemnation of delay of 14 days in preferring the matrimonial appeal. Put the issue notice. Matrimonial appeal. The matrimonial appeal has been preferred against judgment and decree so and so passed by so and so. Issue notice returnable by 6 weeks. Let steps be taken for service of notice upon the sole respondent by registered post with AD. Steps within 2 days. List after 6 weeks along with service report. The respondent may file objections after such appearance. There are some GR2, Mr. Dhar, we can have your matter because if the hearing starts, you will be unnecessarily waiting. We'll have it tomorrow or day after?
Well,
okay. Do 3A Dhar learned counsel for the applicant. Applicant is present. A prayer for accommodation has been made on behalf of Miss Ajahan, learned APP. Para, considering the above, list on Wednesday.
9. Applies.
Regular appeal.
Lord Chief.
Regular appeal, why they are neglecting? Of 20 appealers of 2020. PK Sinha, who is PK Sinha? DK Medhi. What's phone number?
POCSO is also there, Lordship. POCSO is also. Under
POCSO is
6
there.
of POCSO.
POCSO is not there. POCSO is there.
Uh,
376D is there.
Lordship.
For D,
Yeah.
is the presence of the respondent necessary? Informant
Okay.
victim?
For
D.
DP.
D is necessary, I think.
That is also framed under POCSO.
Hmm. No, no, he's not been convicted. Is he convicted? There is no conviction. Conviction, he was charged under 4 and 8 of POCSO. But is there a conviction? Just check.
Uh,
I don't think there's a
Section
conviction.
6 of
Conviction is 376.
Yes. Conviction is only under 376. Please check.
uh, for 70, 30. One.
Who acquitted of the charges under
POCSO.
POCSO.
POCSO, there is an acquittal.
Acha.
Para 25 of.
Yes.
judgment.
Paragraph 25 of the judgment.
Paragraph 25 of,
Of the judgment.
yes. There is no it now.
No clinching.
Huh.
Then 376D is the conviction.
Yes. All other sections they were acquitted.
Yes. Now, under 376, is it mandatory?
That is what. Yes, that.
I think it is there. PNI.
Rape cases. You have to fill
Photo-
out that notification.
Hmm.
for the court.
Nayak case.
Subsequently, that notification was made.
Is this for Nayak only?
Deepak.
Deepak Nayak. Nayak.
This thing. Three 376 AB, 376 DA, 376 DB, 376 D is not there.
D is not there.
Not- 373 AB, DA and DB. Only. Where requirement is there.
Ekho notification apply to division. Please transmit to our court master.
Hello.
We'll have it.
The judgment.
No, not the notification.
Notification, I'm saying the judgment.
Oh.
Notification I don't have. Sir,
No, but notification has been issued in
Ah.
terms of the judgment.
yes, yes.
But you can have that relevant paragraph also, that
A
is
lot.
enough.
I'm sending it.
And we'll have the notification also, not an issue.
Uh,
Uh,
Yes.
But where are the council?
Sinha.
PK Sinha. PK Sinha, DK Medhi.
the above paragraph.
We'll adjourn this, we'll have the non-appeals for the appellant on calls. Two appellants,
Yes, two
appellants on call, whereas Ms. Jahan Learned APP is present for the state. Full stop. Para. In the interest of justice, matter is adjourned to be listed after a week.
Wait, period. Here in this case, the appellant was convicted under section 302 and 201 of IPC. For imprisonment for life under section 302 and 3 years for under section 201 of IPC. FIR, your lordship will find at page 4.
Yes.
Page 4 is the FIR. The informant is the mother of the victim, lordship. I have the honor to state that around 3 p.m. yesterday, that is on 5/12/2016. Lordship, may kindly note the time, that is 3 p.m. 3 p.m. yesterday, that is on 5/12/2016. The above mentioned accused called my son, Shiva Mohanto, 8 years, away to his shop at Barangabari. The accused strangled my son to death inside his shop, and in order to conceal the dead body, he put my son's dead body in a cardboard box and threw it in the Batabari field, and tried to destroy all the evidence by burning the dead body along with the cardboard. I therefore pray to you to take necessary legal action against the accused person. Your lordship, I have said that, can you note that time that is mentioned as 3 p.m.
Yes.
Because lordship, here your lordship will find that one witness said that he saw the dead body at 3:30 p.m. And this time is relevant because the body, the skeleton of the dead body was found. And the time, if it is taken at 3 p.m., within half an hour, the whole body cannot be burned, in the situation where it was burned. So therefore, I was pointing out that time may be mentioned. Okay. Now, lordship will find PW1 at page 8. Jayanta Kumar Bora. He is a he conducted inquest over the dead body. Page 8. On 6/12/2016, I was posted as circle officer cum executive magistrate at Morigaon. On the same day, I conducted inquest of deceased Shiva Mahanta, an 8-year-old boy, son of late Lal Mahanta. I conducted the inquest at the premise of Morigaon Civil Hospital in connection with Morigaon PS case number 409 of 2016. I saw burn skeleton of the deceased. The skeleton of the dead body was identified by the mother of the deceased, namely Ritamani Mahanta, by watching clothes of the deceased. Clothes. No, doubtful of crossed by examination. The mother of the deceased suspected that the clothes had were belonged to the deceased. I did not see those clothes. So specific question was put to PW1 also and to the victim, who is the mother, Lordship, that whether those clothes were produced, because the entire body was burned, and whether those clothes will be there or not, because of that, Lordship, the specific question was there. The mother, I did not see those clothes. The deceased was identified by police. It is not a fact that I falsely inserted the name and address of the deceased. PW2 is the informant, mother of the victim. I am the page 9. I am the informant of this case. Exhibit 2 is my Azhar. Exhibit 2.1 is my signature. The deceased Shiva Mahanta was my son. I know the accused person. His name is Moni Kakoti, who has a shop near my house. The accused also runs business of Xerox and computer photo printing and other activities from his shop. The alleged incident took place more than 1 year ago. At the time of occurrence of the incident, my son, deceased, was 6 years old. My husband died in the year of 2015. After death of my husband, the accused person started to induce me by various means. I have 3 children. The accused used to influence and persuade to go with him to some other place. I had refused the accused of his proposals as I was already married having 3 children. When I told the accused to inform his family members about his bad intention, he threatened me to kill. The accused also used to show affections to my minor son. He saw me with bad intention. The deceased was my youngest son. Prior to about 10 days of occurrence of the incident, the accused came to my house at night and called me from outside by knocking at my windows. He knocked the window several times and asked me to open the window. At that time, I was sleeping. My eldest son, he was not examined, Lordship. My eldest son was watching TV at that time. My youngest son, he is also not examined, was another son was there, Lordship. My youngest son, deceased, was sleeping with me. I got up from bed upon hearing his knocking at my window. I did not open the window, though the accused requested to open the same for several times. My eldest and middle son also came to know about about his disturbance. So two sons apart from that, this is where there. They also scolded the accused from inside the house. I told the accused from inside my house that I have no relation with him, and also asked him not to talk with me and not to come to my house. On the date of occurrence of the incident, I went to paddy field for cutting paddy. At about 4 p.m., I came back to my house and found my youngest son Shiva Mahanta missing from my house. I searched him a lot, but I did not find him out. My eldest and middle son also searched him, but all of us could not find him out. We also informed our neighboring people. They also kept on searching my youngest son. When all of us failed to find him out, then I, along with many other village people, went to Morigaon Sadar police station to inform the incident. Prior to visit to police station, my eldest son went to the shop of the accused with my mobile phone to print out photograph of my missing son from the memory card of my mobile phone. There were many photographs of our family members stored in my mobile phone. The photographs of my youngest son deceased were also stored in my mobile phone. However, after examining the mobile phone, the accused told my eldest son that there was no any photograph of my youngest son deceased in the memory of my phone.
Sure.
It was believed that the accused deleted the photographs of my youngest son from the memory card of my mobile phone. Accordingly, my eldest son informed me that there was no photograph of the deceased in my mobile phone. Prior to my visit to the police station, my sister-in-law, Pranita Mohanta was examined as CW2, and she did not support this fact. My sister-in-law, Pranita Mohanta, told me that she saw my youngest son playing with the accused person for the whole day, and the accused was trying to influence him by giving eatables one after another. Pranita is my relative. Husband of Pranita Mohanta is Robiram Mohanta, residing at village Borongabari. Pranita Mohanta is the wife of brother Robiram Mohanta of my husband. Then I went to the shop of accused person, but the accused person was not in his shop, but the shop was open. There is a shop of Mukunda Mohanta. He was examined as CW1. Mukunda Mohanta near the shop of accused person. On being asked, Mukunda Mohanta told me that he saw accused Monika Koti carrying a big carton in his motorcycle and was going somewhere. The accused returned back to his shop at about 7 p.m. Then I again went to the shop of accused and asked him about the whereabouts of my youngest son. But the accused person denied that my son was with him on that day. I asked the accused to print out the photographs of my son, as we very often go to his shop for printing our photographs. I thought that our photographs must be preserved in the storage of his computer. But the accused told me that there was no any photograph of my son stored in his computer. We accordingly informed police about the status of missing of my youngest son. We spent the whole night in tension. On the next day, police informed me that a dead body corpse was recovered and asked me to come for identification. Accordingly, I went to the Morigaon police station. I saw the whole dead body of the corpse got completely burned, and I identified the dead body as my son by his clothes, since police also recovered those clothes. My signature was obtained in inquest report. Exhibit 1 to his signature. I finally identified the deceased by seeing his clothes. I became confirmed that the burned dead body was belonged to my deceased son Shiva Mohanta. Then a written azahar was lodged before the police station. Police asked me about the details of the incident. On being asked by police, I strongly told police that I have complete suspicion over the accused person with regard to the involvement in the alleged incident. When the dead body was discovered, dead body was discovered, accused was also brought to the police station. Police arrested the accused after hearing my version. After arrest, police interrogated the accused, who confessed his guilt. Police told me that accused confessed his guilt. I also heard that the accused pretended to kill me and my other two sons. After the incident, accused went to jail, and after coming out from jail, the accused kept on threatening me and my relatives by various means. Once he threatened me that he killed a person at Maharashtra and he can also kill me. The accused also threatened Pranita Mohanta and his brother Babu in respect of the instant case with regard to death of my son. Police asked me in details about the incident. Page 12, cross-examination part. I did not see the occurrence of the incident. The shop of the accused is situated in a Chariali. There are near about 40-50 shops at that point. So here just I'm pausing for a moment. Lordship, may I kindly see the sketch map, the place of occurrence. That will give a clear picture that your Lordship will find. Page 89.
Yes.
Lordship, may I kindly see that place of occurrence is A, that is adjacent to the road. Top of Moni Kakoti, that is the adjacent to the place of occurrence. 3 rooms are there, it is shown. Page 89. Then your Lordship will find C, that is half wall. And next to it, Lordship, Gotham Hardware and Recharge Bhanda. That is, then your Lordship will find E. E is LP school. And your Lordship will find in the evidence that on that day, school was open and number of persons are going to that school at that relevant time. That Parangabari MB school is also there, F adjacent to it, just opposite the road. Then house of Rita Mohanto informant. No, I have to this one. Monica Kote is top. Recharge. So what I was placing before Lordship that it is adjacent to the road, and when it is Lordship that dead body was completely burned, it takes time. And that you were relevant for your Lordship has in that other about 40
6-year-old baby.
Yes.
How long will it take?
That,
How big will be a 6-year-old?
that is,
6-year-old.
about half an hour, 1 hour, 1 hour will take. But the other people's houses are there, residence school is there, that your Lordship will find subsequently also.
No, the aspect of taking time for burning is different from your other possible argument that the occurrence took place in a busy locality.
Busy locality.
What is the occurrence of taking away, not the burning? Burning is not in that place.
Burning is in that place. Because your Lordship, place of occurrence, it is state.
Burning, he was taken to a field.
So it was recovered subsequently from the field. But
No, the burning, the skeleton was recovered. So obviously it could not have been burned there in the middle of the shop. Because the witness had said the person who stayed, mother said that the person who stayed near, whose shop was nearby, he said that he saw the appellant carrying a big box and going away somewhere. That is in evidence. Now that burning, where is the burning?
That your Lordship will find that apart from that, in the sketch map, it is said that place of occurrence is near the shop of the accused. Apart from that, there is nothing that it was burned in the pit, and subsequently it was kept in the near, the skeletons were kept here. That is, Lordship, may I kindly see the evidence that we will make it clear. So may I read first? There are, I'm reading from page 12. There are near about 40-50 shops at that point. The daily vendors also come to that place for selling items. There are 2 schools near my house. The incident occurred on a Monday. School children come to those schools along with their guardians. The shop of the accused is facing towards the road. The accused has a very small shop. The police asked me about the incident on the next day of occurrence of the incident. Some burnt piece of cloth of my deceased son were removed. Police displayed me those burnt piece of cloth of my son. Today I did not see those burnt cloth in the court. So a specific question was there regarding those cloths. It is not a fact that I did not state before police that Pranita Mohanto told me that my son was playing for the whole day and the accused was inducing my son by giving some eatables to him. It is not a fact that I did not state before police that one Mukunda Mohanto told me that he saw the accused carrying a big carton in his motorcycle and was going somewhere else. It is not a fact that I did not state before police whether whatever I had stated in my examination in chief in court against the accused. It is not a fact that police did not state me. It is not a fact that it should be I did not state to police that the accused confessed his guilt. It is not a fact that the accused did not threaten me by various ways after releasing from jail temporarily. It is not a fact that the accused did not threaten me or by saying that he killed a person in Maharashtra and so he can also kill me. I know one Lokhi of Daponiguri. It is not a fact that said Lokhi had insisted me to lodge the case against the accused. It is not a fact that I have stated falsely before the court. It is not a fact that I did not hear the version of the accused confessing his guilt at the police station. It is not a fact that accused did not confess his guilt before the police. Page 13, PW3. I know the informant Rita Mahanta who is from our locality. The deceased, namely Shiva Mahanta, was the son of the informant. I also know the accused Moni Kakoti who has a stationery shop on the opposite side of the house of informant. The alleged incident took place about 1.5 years ago. Deceased was around 7 years old at the time of occurrence of the incident. The deceased frequently used to go to the shop of accused. I saw the deceased at the shop of accused on many occasions. On the date of occurrence of the incident, a hue and cry took place at our locality with regard to missing of the deceased. The mother of the deceased, that is the son, was seen to have searched for her missing son. I saw a gathering of village people at the shop of accused. I also went to the shop of accused and saw police interrogating the accused. The accused was alleged to have committed the offense of murder by the informant. I saw police asking the accused as to how he had killed the minor son of the informant. Upon interrogation, the accused confessed before police and village people that he had killed the minor son of the informant at his shop by strangulating him. So, and thereafter put the dead body of the deceased in a cartoon and then took away the said cartoon to somewhere else in his motorcycle. I and many others saw and heard the confession of the accused in respect of killing of the deceased. Thereafter, police arrested the accused. Later on, I heard that accused Moni Kakoti used to show bad intention to the informant. Police did not record my statement. Police was interrogating the accused on the day of occurrence of the incident. Numerous people were gathered around the shop of accused on the day of occurrence. I could not recollect who were present there. The informant is my relative. It is not a fact that I was tutored by the informant to state against the accused. It is not a fact that the accused did not confess his guilt before police and village people. It is not a fact that I did not hear the accused confessing that he committed the crime. It is not a fact that the accused person was not involved into the alleged offense. It is not a fact that I deposed falsely before this court. Now, PW4, page 15. I do not know the informant. I know the accused. The alleged incident took place about 1 year ago. The accused had a shop at Borongabari village. On the date of occurrence of the incident, at the instruction of police, I accompanied police and came to the shop of the accused. The accused led us to his shop. When police came to the shop of the accused, many village people gathered around the shop. Police brought me to the shop of the accused for recording videography of the confession of the accused. The accused confessed before police that he had killed a minor boy of his locality. The accused explained in his confessional statement that as to how he had killed the deceased. I recorded the statement and confession of the accused in my video camera. I also heard the statement of the accused as I was recording his statement. After recording of the statement of the accused in my video camera, I transformed and downloaded the said in recording into CD. Police seized the said CD from me. Exhibit 3 is the seizure list. Material Exhibit A is the state CD. Exhibit 4 is another seizure list, and Exhibit 4.1 is my signature. Cross. The OC of the police station called me for recording the version of the accused. When I went to the police station, I saw the accused already being arrested. There was handcuff at the hand of the accused. 2 police vehicles went to the place of occurrence, taking me and the accused person. I could not recollect whether CRPF Jawans accompanied us or not, but we were accompanied by some armed guards. I used a Sony camera having memory card for recording the videography of the version of the accused. My camera was having inbuilt memory. It is not a fact that I did not make any video recording of any such confessional version of the accused. It is not a fact that the accused did not confess his guilt before the police and me. It is not a fact that Material Exhibit A is not an authentic CD of videography of the confession of the accused. As far as I remember, I made 2 CDs. It is not a fact that I have deposed falsely before this court. Now, page 17, PW5. I do not know the informant of this case. I do not know the deceased of this case, nor have I heard his name. I do not remember the date of the incident. On the day, one day, someone from the village telephoned me and told me that he had seen a half-burnt person by the side of a pukuri in a paddy field. I went to that place, and thereupon I made a phone call to the police station. Police told me that they are proceeding to that place. Police came to that place. Some bones of the half-burned dead body were lying around. Police seized those bones. Police put the dead body in a jute sack and took away in a vehicle. Cross. The police had questioned me. When police had reached that place, lot of people had assembled there. The dead body was not in a recognizable state. From the bones, it could be made out that it was a human being. The body was in pieces. Page 18, PW6. I do not know the informant and deceased of the case. I also do not know the accused of the case. The incident had taken place long time back. I do not remember exactly. One day I heard that about 1.5 kilometers away from my house, one small boy was killed and kept in a half-burned condition. Police seized some body parts and some burned clothes in my presence. Exhibit 5 is the seizure list pertaining to the state seizure, and Exhibit 5.1 is my signature thereof. Cross-examination. I reached the place of occurrence after the arrival of police. There were other people apart from me. I have put my signature in the seizure list. On the road near the place of occurrence, I do not remember whether anything was written on what paper when I signed. Police did not show me anything. I was not shown the seized item. Police talked to me briefly. I did not state before the police that one small boy was killed and kept in a half-burned condition. I have not seen any spread out body parts of the dead body. I did not see the dead body. Page 19. PW7. I know the informant of this case. I also know the deceased. I know the accused person who is present in the dock today. We are all from the same village and neighboring person. I have heard about the incident. The incident had taken place about 3 years back. On the day of the incident, the mother of the deceased had gone to the paddy field for working. The deceased was a school-going child. At that time, the child was in his house. I heard that the accused had taken away the child from his house and left him dead in the paddy field, from where police recovered the dead body. Later, the police arrested the accused person, and when I was going home from work, I saw a large number of persons along with the accused and the police. I heard the accused saying in front of the people where police was also present and he had killed the deceased. On the day of the incident, I returned to my house at 3:30 p.m. from my office. At that time, I was having several office papers with me, and therefore I stopped at the place of gathering of persons for a short while. At that time, there was lot of commotion at the gathering, and I did not hear anything from the accused. I heard about the incident from the other people present there. At that time, it would be about 4 p.m. By that time, police took away the accused to the police station. I did not find the accused at that time. I have not heard as to what the accused had stated to the police. What I have deposed in the chief is only on the basis of what I heard from the other person. It is not a fact that I have stated today regarding the incident, and the involvement of the accused in the incident is false. The informant is my close relative. It is not a fact that I have deposed falsely today as because the informant is my relative. It is not a fact that the accused is innocent. Page 21 PW8. I know the informant of the case. I do not know the accused person of this case. The incident had taken place more than 9 months back. On the day of the incident, I was in the police station, and my OC told me that one skeleton was lying in the field, and accordingly, I, along with OC and one magistrate, went there and saw the skeleton. It had some flesh, though body was not there. We saw a burnt cartoon by the side. Accordingly, the said skeleton was brought to the Morigaon Civil Hospital, Morigaon. I could not recognize as to whom the skeleton belonged. The skeleton did not have flesh on the face, and skull was present. Page 22. PW9. I know the informant and the deceased of the case. I also know the accused person, and I have seen him in the dock. The incident took place about 2 years back. At the time of the incident, there was hue and cry in the village that the accused had killed one child. Cross-examination. The informant is my relative. Today I have come to the court along with her. I have not seen as to how the incident of death of the child took place. I have heard from the villagers that the accused had killed the child. I do not remember the name of the villager. It is not a fact that I have falsely stated that I had heard from villagers about the accused killing the child. It is not a fact that the accused is not guilty. It is not a fact that I have deposed falsely. Now, PW10 is the IOLOT, page 23. On On 5/12/2016, while I was working as attached officer in the Morigaon police station, one Srimati Rita Mohanto lodged an intimation to the OC that her minor son was missing. On the basis of the said intimation, GT entry number 142 dated 5/12/2016 was made, and I was asked by my OC to inquire. Exhibit 5 is the extract copy of the aforesaid inquiry, but could not find
Aforesaid
anything.
GD entry.
GD entry. Extract copy of the aforesaid GD entry. Thereupon, I, along with the state Rita Mahanta, went out for inquiry, but could not find anything, and I returned to the police station. On the next day, VDP secretary of the village Tikaburi informed my OC on telephone that one skeleton of a 8-9 years old child was lying on the paddy field in village Pottabari. With regard to this information, GD entry number 159 dated 6/12/2016 was made. Exhibit 6 is the exact copy of the state GD entry. Thereupon, I, along with my OC and staff, went to that village, and at the stated place, we found near Birina trees a skeleton of a child. There were blood stains on the skeleton, and it appeared to us that the incident was not very old. We also saw some burned leaves of birina trees, and we also found some burned paper cartons. Some flesh from the skeleton were found to be lying scattered in the vicinity. We also found some half-burned cloths near the skeleton. From the said place of occurrence, we searched one piece of burned vest with the writing RUGB Sports, one burned piece of sporting genji, one piece of burned long pant, some burned pieces of cartoon. These materials were seized by Treasury, which is Exhibit 5, and Exhibit 5(2) is my signature thereof. The seized materials are Material Exhibit B. At that place, lot of persons had assembled. In the meantime, I examined some of the witnesses. The skeleton was packed and then taken to the Morigaon Civil Hospital, Morigaon. At the state hospital, inquest was done by magistrate. The seized clothes were shown to Srimati Rita Mahanta, who identified them as belonging to her minor son. Thereupon, upon making inquiry by myself and my OC, we suspected the involvement of Sri Moni Kakoti in the incident. On 6/12/2016, a formal azahar was lodged in the police station by Srimati Rita Mahanta, whereupon Morigaon PS case number 409 of 2016 was registered under section 302/201. Upon questioning, the said Moni Kakoti admitted that he had killed the child, and thereupon he was put under arrest in the police station, and on the next day he was forwarded to the court for remand. On 7/12/2016, the skeleton was sent to Guwahati Medical College and Hospital, Guwahati, for postmortem examination. As the same could not be done in the Morigaon Civil Hospital, Morigaon, and the same was done on 8/12/2016 in Guwahati Medical College and Hospital, Guwahati. During interrogation on 8/12/2016 of the accused, during his remand, he stated that he would show as to how he committed the incident. Accordingly, on 9/12/2016, along with my OC and circle officer S.S. J. Bora, I went to the place of occurrence along with the accused upon his showing, and thereafter one police videographer was called to record the narration by the accused as to how he committed the incident. After completion of the video recording, the same was seized by Exhibit 4, and 4(2) is my signature thereof. Material Exhibit A is the state CD of the video recording. Thereafter, the statement of some witnesses were also taken. During investigation, I had prepared a sketch map of the place of occurrence. Exhibit 6 is the state sketch map, and Exhibit 6(1) is my signature thereof. Subsequently, I came to know that pursuant to the postmortem, one piece of bone was sent to the Central Forensic Laboratory at Kolkata, but I had not received any report of the same till the time of filing charge sheet. Later, the postmortem report was collected. During investigation, I also seized the motorcycle in which the accused had carried the dead body in a cartoon. By Caesarly Swenson. On the basis of the investigation and materials collected therein, I submitted charge sheet against the accused Monique Akoti under section 302/201 IPC. Cross-examination. Initially, I and my OC Sri Prakash Chandra Hazarika had suspected the involvement of the accused in the incident. The informant lodged the same after seeing the seized clothes of the deceased. At the time of the video recording, about 5 police persons were present along with some armed. At the time of conducting the video recording, we did not take signature of any villagers at that spot. None were present there. I have not submitted any prayer before the court to record any confessional statement of the accused. The accused was arrested in the police station itself. I do not know as to why the accused had come to the police station. The accused was arrested after the recovery of the skeleton. From the skeleton, it could not be recognized as to whom it belonged to. DNA testing is one of the ways to determine the identity of the skeleton. I have not mentioned in my case diary any reason for not forwarding the accused to the court for recording his confessional statement. The distance between the Morigaon police station and Morigaon court would be about 150 to 200 meters. The accused was in police remand for 3 days during police investigation. I have not found any eyewitness during my investigation. It is not a fact that the accused had not confessed to committing the incident in front of us. It is not a fact that during the police remand, the accused was subjected to torture. It is not a fact that the accused was not forwarded to the police for recording confession due to his non-involvement in the incident. During investigation, we felt that the accused was somewhat mentally disturbed at times. We had not forwarded the accused to the doctor for mental health checkup prior to his confession before us to check whether he was mentally fit to confess freely. It is not a fact that I did not find involvement of the accused in the incident case. And it is not a fact that taking advantage of any mental instability of the accused, I have completed the investigation against him, submitting charge sheet. It is not a fact that his confession before us was extracted by inducement and allurement. It is not a fact that the video recording made by me during investigation is not legal, and it is not a fact that the confession of the accused in the video recording is not out of free will and sound mind. It is not a fact that I have not conducted the investigation properly. It is not a fact that I have not implicated the right accused, and not a fact that the accused is innocent. Now, PW 11 who conducted a postmortem, that relevant part your lordship will find page 29, opinion as to cause of death. At page 29, your lordship will find opinion regarding cause of death is kept pending till the receipt of toxicological analysis report from the DFS Kahilipara. That report was never produced by the prosecution. Lordship. The actual cause of death, that is not there in that. whether it is homicidal, whether it is electrocution, or whether it is other thing that is not. The cross of the doctor, the cause of death was kept pending on receipt of toxicological analysis report. At the time of postmortem, the case property consisted of a skeleton only. In this case, the question of rigor mortis does not arise because there was no muscle and soft tissue. The approximate time since death was determined on the basis of examination of the brain, which was found to be soft and decomposed. The age of the disease was determined on the basis of the examination of mandible and teeth. The identity of the person is difficult to be determined by the naked eye on the examination of the skeleton. The identity of the person in such a case can be confirmed by DNA profile. For DNA profiling also it was done, but that report was not produced. Page 30, your lottery will find CW1, Mukunda Mohanta. That PW2 said that
This is the nearby shopkeeper.
Yes. Accused Moni Kakoti is known to me for having shop near to my shop. Moni Kakoti has gift items, Xerox, computer printing, etc. shop near to my shop. Informant Rita Mohanta is my maternal aunt in relation. Deceased Shiva Mohanta was the youngest son of Rita Moni Mohanta. On hearing hue and cry at the residence of Ritamani Mohanta, I went to her house and came to know that Shiva Mohanta was missing from the house. On the next day morning, from the locals, I came to know Shiva was burned by accused Moni Kakoti. So here he said nothing about those cartoons, taking a cartoon. Crossed by prosecution. It is not a fact that I know that Shiva, the deceased, used to frequently visit the shop of accused Moni Kakoti. It is not a fact that on 5/12/2016, I have seen the deceased Shiva in the shop of Moni Kakoti. It is not a fact that on that day I have seen the accused Moni Kakoti in talking something in a big cartoon, taking something in a big cartoon. It is not a fact that today I have deposed falsely to save the accused. Crossed by defense. I have no personal knowledge on the death of Shiva Mohanta. I did not go to the place where the dead body was found before police. Before police, I have also stated about my ignorance about the fact of death of Shiva Mohanta. I cannot say the name from whom I have heard the accused caused the death of Shiva Mohanta. It is not a fact that I have deposed falsely that from the locals I came to know Shiva was burned by accused Moni Kakoti. I have never seen Shiva in coming to the shop of Moni Kakoti. Now CW2, Pranita Mohanta. About her lordship that PW2 said in page 10 that the entire day he was playing with the deceased. The appellant was playing with the deceased and has given some eatables. Accused Moni Kakoti is known to me being shop near to my house. Moni Kakoti has gift items, Xerox, computer printing, etc. in my shop. Informant Ritamoni Mohanto is my sister-in-law, wife of my husband's elder brother. I and Ritamoni Mohanto reside in nearby residence. residences. Deceased Shiva Mahanta was the youngest son of Ritamani Mahanta. On 5/12/2016, at 12 noon, I have seen Shiva in the shop of accused Moni Mahanta with a chips packet, and by taking that packet, he came to house. On my asking, he told me that Moni Dada accused has given him the said chip packet. After some time, he left my house for going to his house. On evening hours, I have seen Ritamani Mahanta in searching Shiva Mahanta in the nearby houses. We have also searched for him. On the next day morning, I came to know that police found one dead body in a field. I did not go there. I also came to know Shiva was burned by somebody. Subsequently, Ritamani told me that accused Moni Kakoti has set her son Shiva ablaze and caused his death. Police did not interrogate me about the incident. Crossed by prosecution. On 5/12/2016, at daytime, Ritamani was working in nearby field. I have frequently seen the deceased Shiva in the shop of Moni Kakoti. Accused used to shower love and affection on Shiva Mahanta. I know that 2 days back of this incident at night hours, accused Moni went to the house of Rita Mahanta and called her through a window, and on this Rita Moni Mahanta scolded the accused Moni Mahanta and refused to open the door. Rita Mahanta is a widow. After 2 days of this incident of missing of Shiva took place. On 5/12/2016, I have seen the deceased Shiva Mahanta in coming and going to the shop of Moni Kakoti. Crossed by defense. I have no personal knowledge on the death of Shiva Mahanta. Rita informed me that accused come to his house on late night hours. Today in court, Rita Mahanta is present in court campus with me. It is not a fact that I have deposed on being tutored by the informant. There were several shops near to my shop of accused. Near to the shop of accused. The shop of accused is visible from the entry point of my house. It is not a fact that accused is no way connected with the death of Shiva Mahanta. It is not a fact that Rita did not inform me that accused set her son ablaze. It is not a fact that I have deposed falsely in the interest of informant being my sister-in-law. Now, before going further, Lordship may kindly see the circumstances which were taken into consideration by the trial court, that your Lordship will find at page 69. Page 69, paragraph 41.
Yes.
From the discussion of the evidences relating to the circumstances as described herein before, it appears that the following stands proved beyond reasonable doubt. A. That the accused Moni Kakoti alias Bhupen Chandra Kakoti kept ill intention on Srimati Rita Mahanta, the mother of the deceased, who is a widow and living with her 3 children. B. That the accused reflects his ill intention and gives proposal which was refused by Srimati Rita Mahanta. C. That Shiva Mahanta, the youngest son of the informant, used to frequently visit the shop of the accused. D. On 5/12/2016 at about 12 noon, the deceased Shiva Mahanta visited the shop of the accused, and the accused offered one packet of chips to him, which he took to the house of CW2 Srimati Pranita Mahanta, and thus it appears that he was last seen with the accused. So here it was not last seen with the accused, because after last seen with the accused, that boy came to the house of CW2. Thereafter he went to his house, not to other person's house.
CW2 is Pranita.
Pranita,
Who came to Pranita's house?
the victim boy. From the top of the appellant, after taking tips, he came to the house of CW2, Pranita. Then he went back to his house.
Let's see again.
CW2, Lordship, may kindly see.
31.
Yes. On 5, second paragraph, I am reading, Lordship. Page 31.
Yes.
On 5/12/2016, at 12 noon, I have seen Shiva in the shop of accused Moni Mahanta with a chip packet, and by taking that packet, he came to house. On my asking, he told me that Moni Dada, accused, has given him the said chip packet. After some time, he left my house for going to his house.
Whose
So-
house?
Going to his house.
His means?
That is not clear. It is not the accused. That is not proved circumstance. That is what
No,
I
no.
am.
His means the victim's house or the accused house.
In my humble understanding, subject to correction, also it will be the victim's house, because he said that after some time he left my house for going to his house. No. Because accused house was not near, where accused shop was there.
Yes.
And then page 69, Lordship. Then E. The accused intentionally denied to provide photographs of the deceased child from the mobile phone of the informant as well as from his computer, which the informant believed to be kept in the memory of her mobile phone and in the computer, as the accused had a business of photo printing through his computer system, particularly while knowing that son of the informant was missing and she needs a photograph to give the same to the police. So here also, Lordship, it is not a proved circumstance, because the police investigating officer could have seized the computer and it could have been those, if it is deleted, they could have retrieved it and could have placed before the court that this is the deleted articles which were retrieved from the computer. But that was not done. It is only the oral statement of the informant. Because to convict a person on the basis of circumstantial evidence, those circumstances has to be proved circumstance.
Yes.
That recovery of the dead body on 6/12/2016 from the field in half-burnt condition with some half-burnt paper cartoon, and the fact that the dead body was identified by the informant through cloth, which was further corroborated by the medical officer on the east side. So these are the circumstances. Here, from my humble understanding as subject to correction, what my learned friend says, these circumstances do not point at any point the guilt of the accused person, so towards the guilt of the accused person. And then now your lordship may kindly turn to page 33. This is the 313 statement of the accused. Start from page 33. Just I am not reading the entire 313 lordship. Just what I am trying to point out before lordship, that it ends at 34J. And questions are 84. Your lordship has seen that for five circumstances, 85 questions were put to him. And your lordship has seen the recent judgment of Honorable Apex Court, that it is said that only incriminating circumstances had to be put to the accused. so that he can explain the incriminating circumstances, Lord. And here, after the last question, your Lordship will see
The purpose of 313 that it should not be inadequate.
inadequate, and
No, these questions put to him should not be inadequate, giving him a fair chance to explain.
yes,
Now, putting some more questions will not vitiate 313.
yes, that is regarding second part. I am coming to that.
If it's less, some incredible circumstance material not put to him,
Not put to him.
then
that,
it may not be proper.
yes,
But
that is what
here-
I am now placing to your Lordship. That question number 85, Lordship may kindly see. Last question, 34J. Whether you have anything more to say on the case and the evidence. After that, it has to be fixed for the defense evidence. Because Lordship may kindly see section 313, there are two parts. Just I am saying to your Lordship for a moment that section 313 CRPC, Lordship.
Yes. Yes.
In every inquiry or trial, for the purpose of enabling the accused person to explain any circumstances appearing in the evidence against him, the court A may at any stage without previously warning the accused put such questions to him as the court considers necessary. B shall, after the witness of the prosecution have been examined and before he is called on for his defense. So before he is called on for his defense, that means after recording 313, there has to be a date fixing for evidence of the defense, Lordship. But in the present case, subject to what my learned friend says from the record, Lordship, it appears from here, Lordship, page 35 of the paper book. Next page, your Lordship will find from the judgment. But I find it was for SD 5/8/2021. That is 313 was recorded. Page 35, that dates are there. And then date of argument 1/9/2021. So there has to be a date for the defense evidence. In the present case, probably no such date was fixed, and even it was not asked to him whether he wants to adduce any defense evidence or not. So that 313 was not properly recorded. That is my what I'm saying. And before what it 5/8/21. 5/8/21. This is my humble submission before your Lordship that the circumstances which are relied on by the learned trial court to convict the appellant are not the proved circumstance and do not complete the chain of circumstances. Because here in this case, the FSL report and the DNA report were not produced till conclusion of the trial by the prosecution side. And the circumstances which were relied on by the learned trial court may at best, Lordship, that raise suspicion against the accused. And it is settled law that suspicion cannot take place of proof. Highway 21 second. Here in this case, Lordship, he is in custody since 11/5/2018. He remained as under trial with the president. Initially, he was released on bail. Subsequently, he was again taken into custody. For almost 7 years, he is I wait.
Okay. Yes, madam.
For the contract. Not the case of then was asked. Wait.
What about the date, particular date, statement of defense, 5/8 or something?
5.
5/8, that is the date.
Yes, the same 5.
Okay, okay, okay.
So it fix 18/8 for argument. FSL report never came. FSL report did not come. Let's stop.
Yes,
Fact, this is a 302 case, so my first endeavor should be that it is homicide. There is a, so, but, of course, subject to correction, in the FPM report also, there is nothing so that it was a homicide. And they tried to collect the FSL report, it didn't come for 2 long years, and they said that enough.
now how can a death be either suicidal or homicidal?
In order
Or
to,
it may be accidental.
Yes.
It may be accidental.
then it will not come within
No, no,
302.
now what is the circumstance? How was the body found?
Body was found in the
Body was-
next day,
Next day of a 6-year-old boy,
yes.
half
One
burnt,
person informed over telephone to the VDP,
half burnt,
half burnt. But clothes were also, perhaps clothes were taken down or,
and there were pieces.
they were in pieces. Flesh were scattered,
Glass was scattered.
but there was blood, so they considered that it was a recent case. But then the identification would have been very difficult unless the DNA test is done. But clothes, they say there are pieces.
Mother
of-
has identified
Mother has identified by the clothes,
clothes.
where rugby and all were
Yes,
written.
yes. And
But-
the age of the victim in the PM has been his matches between
Huh.
6 to 9.
Yes, 6 to 9,
So it's not
lesser
that
than 9.
you may be correct in stating that by clothes, it may not be assertively determined that he is the person. It may be very easy to change clothes, but the age, the locality where it is found,
The feet near the
near
pond,
near the pond.
the pond. Of course, circumstances not to have seen this already. The accused was luring.
What is this nearby shop owner say before the police regarding the witnessing
The carton being
cartoon
taken.
being taken?
That I,
And
in his statement before. court,
statement
he
in the court, he does not say anything.
He did not support. The
No, he did
own-
not say anything
Did
rather.
not say it.
And was the cross put to him?
No, he said, it is not a fact that on that day I have seen accused Monica Koti taking something in a big carton.
No. Come to page 30, 31.
Yes,
rather,
30,
30,
30.
30.
The third line in his cross.
Yes. Please read it.
It is not a fact that I know Shiva, the deceased, used to frequently visit the shop of the accused. It is not a fact that on 5/12 I have seen the deceased Shiva in the shop of Monica Koti. It is not a fact that on that day I have seen accused Monica Koti taking something in a big carton.
Please see,
Taking big carton is okay.
yes, please see the,
Yes, his 161 statement. Mukunda, I doubt he had given statement before. Court witness ahead.
police. Yes.
I doubt he has given statement before police, otherwise he would have been a
Yes,
PW.
he's a court witness.
He is a court witness. And it is said that they could come to know about them from the statement of PW1, and that is how the court called. Still, I'll check the,
No, you're correct. Otherwise, he would not have been a court witness.
not that, doesn't touch it.
Hmm.
Both sister-in-law and he were not there as a witness.
PW 3. Yes. Hmm. Dulal Mahanta. He heard. Hearsay. Hearsay. Hmm. This videography of the so-called confession We call it so-called because it was not done in accordance with law, essentially. The police personnel, he was handcuffed. But was it seen by the learned court? What is the purpose of the case, making a compact disc?
No, this is actually recreating the scene. He was taken from
Recreating, no,
the,
was it seen by the learned court?
uh,
Not recreating.
no,
It is having a videography evidence of the confession thing.
when he was taken there and
Only by making a videography, it will automatically not become admissible unless it is done in accordance with law. But did the learned court see?
court, whether it was seen, whether it was placed as a material exhibit. Yes, material exhibit
Yes,
A,
it is material exhibit A,
CD.
CD.
And he admitted that he had confessed before police in history one. He said yes.
That will not make
Anyway.
much of a difference.
Will not be an evidence.
But the chain which the prosecution is trying to build up, his ill intention towards the mother, number one.
Yes, that is admitted.
And he is knocking of the window just 10 days before.
Okay,
And he is showing affection towards the children. He was the youngest,
was the young.
6 years. And the other two perhaps were slightly, and
Yeah.
she says that they also scolded him.
Hmm.
Scolded means maybe shouted, why are you here?
The other two shouted, not the youngest
Not
one.
the
I
youngest. He was
remember
sleeping.
it. He was sleeping
Sleeping.
with his mother. Those circumstances
No,
are
that
there.
may be one of the circumstances. I'm not saying that would be the sole circumstance to implicate him. But we have to see whether a chain has been built up.
And whether
Otherwise,
it's a homicidal
6-year-old
death.
obviously it has to be homicidal. A 6-year-old will not be accidental to fall into a fire. And had it been drowning or something else, matter would have been different.
And the doctor also did not return a finding that it was post-mortem. The burning was post-mortem.
Nothing.
Whether he was strangulated, then he was burned as the
Nothing.
prosecution.
Normally, the word ante-mortem is always written.
Yeah, it's
Here
always
not there. Let's again see.
not
The
there.
doctor.
I've checked. Right.
Doctor is PW 11 at page 28 probably, 27 or 28. It's 27 or that part.
Even part page 20.
The cause of the death was kept pending for that report. At the time of postmortem, the case property consisted of skeleton only. In this case, the question of rigor mortis will not come because there was no muscle. The approximate time of such death, since death was determined on the basis of the examination of brain, which was found to be soft and decomposed. The age of the deceased was determined on the basis of mandible and teeth. The identity of the person is difficult to be determined by the naked eye on the examination of the skeleton. The identity of the person in such a case can be confirmed only by DNA file. Nothing else beyond that. Did not say anything. He said that the hyoid bone is healthy. Had it been a case of strangulation, normally hyoid bone gets break. It gets broken. But then here it is healthy.
Because mother said that she could hear from this person that he saw a curtain being taken off. He, as a co-witness, he did not say anything about curtain. But this curtain piece was also found near the place where it was burned. He found burned pieces of curtain. You can't keep a live body in a curtain and they play in a motorbike. That has been the maybe he was made unconscious or he already died. Probably death. Reason of death is not found to be anti-mortem, post-mortem, nothing. No. How will necessary report how can be present here? Acquittal is only from case to be prescribed by poison or something. Not from cases of the of burn to me. They can say the official consideration may be a bone because of a bone to or the explosive or anything. But you never that's not the relevant for whatever opinion may be.
You want to sit happy.
And the CD proximity earlier they we blocked.
But
Next one
this
is from
applicable
the teachers is from very
with us.
something I'll do something that is also found.
Fix.
And at that time,
Same
we
it
also have noticed that when the mother saw that the child
It-
not yet saw was missing, they first went to the shop.
it-
This
it-
was on the
No.
phone.
you see the day. It's up to
And we come to the shop.
Look at that.
We come to page 10. Page 10. The lower part, lower part. The husband of Pranita. Have you got? Husband of Pranita. Here. Madam. Husband of Pranita is so-and-so residing in so-and-so. Pranita is the wife of brother of so-and-so of my husband. Then I went to the shop, the actual person was wrong, but the shop was open. Where are you? Okay. And see, and see this is exactly in the sequence. What will I do? His shop is open, he's not there. Musical person. He says, I saw him going a curtain. He has slightly turned his side, they have turned his side, he has not found him as a PWI. He has found this, opened the for the CW. Was Mukunda examined as by the police under 161?
No,
Not examined.
Not examined. I've checked his check. He was not examined, neither his name was there in the charge sheet. But one thing, Mukunda did not deny of taking the carton. He said there was nothing in the carton. That is what can be deduced from. Lordship will see again his statement.
CW1,
CW1,
page 30.
page 30. It is not a fact that on that day I have seen the accused Monica Koti in taking something in a big carton. He would have said, I have not seen Monica Koti taking a big carton. It is not a fact that on that day I have seen accused Monica
he's
Koti
denying
taking something in a big carton.
So he's denying that he saw.
It is not a fact that that day he
Yeah.
denying
He's denying.
of taking something
Something in a big carton.
in a way,
No.
but big carton he carried, but he denied
No,
he
that
carried
admission-
something.
That admission part was not put to it. Admission part.
It is not a fact that one will see. So he's denying seeing, isn't it?
He's denying seeing, carrying something.
Oh.
That is the interpretation of the people.
Mm.
Big carton is not denying, but carrying something in a big carton. So that is also possible. Taking carton, I do not know whether there is something in the big carton.
Big cartoon is not denied.
That is what.
Something
This
is
is
denied.
what I'm stressing on. Big carton,
It's not denied.
he carried the carton, but something was inside it denied.
Carried the cartoon, that part is not there.
He carried the carton is there in mother's evidence. Oh.
That evidence.
Nah, it nah.
See the evidence of the mother again at page 10.
He had also few contradictions, but then the contradictions are not proved.
No, but yes, no, this is something very important. In the middle part, at page 10.
10 years.
After Pranita, then I went to the shop of the accused person. But the accused person, this is after searching for her son, not getting, then went to the shop. Accused person was not in his shop, but the shop was open.
Where is that?
Page 10.
10 years.
Just little down after the middle part. Pranita Mahanta, have you found?
Yes, yes.
Pranita
Pranita
Mahanta is the
Mahanta.
wife.
Then I
brother.
went to the shop, yes.
Yes.
It's not.
Then I went to the shop of the accused person, but the accused person was not in his shop, but the shop was open.
Yes. He
See,
came back at 7.
He came back at 7.
Where was
She
he?
again went to him. He said that, no, I do not know about your son.
That will be another circumstance. He was not there
He
at
was
that
not there at
relevant
that
point.
time. And this is direct evidence.
Directed. This is when the burning perhaps was
And
going
this
on.
Mukunda Mahanta appears to be a very significant witness. We do not know why he was not examined by the police. Neither he stood by himself as a court witness. But what is also relevant to note is that in the place where the body was found, half burnt or full burnt, you find burnt parts of a carton also.
Carton, yes. Carton by the side. Kept it aside. Clothes also he must have taken it down. I mean, he had to.
How was it? How pieces were found? That is something very.
Had it been burnt with the body, there was no question of.
No, pieces of the body.
Pieces of the body. And pieces of clothes as well.
Clothes.
Where even the alphabets were visible. He must have taken down, he had taken out the clothes from the body. So the circumstances, your lordship, I'll just say a few. One is that ill motive is there.
Just a minute. Yes.
So first will be that ill motive towards the mother. And then the victim keeps going to the shop of the accused person.
Yes.
On the day of third will be on the day of occurrence at 12 noon. He went to the shop of the accused.
Yes.
This is stated by the sister-in-law, the court witness number 2. Then he brought chips. given by the accused person to the house of the court witness number 2.
Yes.
Then, of course, court witness number 2 says that he went to his house. He did not say the word stop. His house. Perhaps it was the house of the victim.
Maybe,
Lordship can see it again.
maybe their own house. Maybe their own house. No, may not be the house of the appellant.
His house.
Hmm.
And we don't know where
But,
the house of the.
But the incident of disappearance was not marked at 12 noon. It was marked around 2 o'clock, after
Yes.
2.
After, because when 3:30 she came back, she found his son missing.
Yes.
Mother, 3:30, I think.
3:30 she came back from the paddy field.
Paddy field. Then she found her son missing. 3:30 or 4. 4. 4 I came back to my house and I found my son missing.
Then,
4 o'clock.
even after having the chiefs going back to his own house,
Hmm.
thereafter we do not know what has happened actually.
Yes.
He might
There
have
the link
gone
is
back,
missing.
gone back or.
Anybody seeing him again after some time is also not there. There, of course, the link is little problematic.
And what else? Manu?
And then they were searching, and then he was not there at his shop. This is another, as your lordship has pointed out. Then 7 o'clock he comes back to his shop.
Yes.
And then mother said Mukunda told her that he had taken a carton, which is not contradicted. The contradictions are not proved. Lordship will see, in her examination in chief, she said there is a shop of Mukunda. On being asked, Mukunda told her that he saw Moni Kakoti carrying a big carton in his motorcycle and was going somewhere. In her examination, cross-examination, she stated, it is not a fact that I did not state before police that Mukunda told me that he saw the accused carrying a carton, but this contradiction is not proved. So that will remain. Her statement that Mukunda told him will remain. So Mukunda told her, and the sister.
Can we come back or what? You want to complete? Okay, just 5 minutes.
And the sister told the informant that the child was playing with the accused for the whole day.
Who told?
Mother said, sister-in-law told her that the child was playing with the accused for the whole day. And in her,
Pronita had said her.
Pronita had told her.
Told the PW2.
PW2. But then Pronita in her examination said at 12 o'clock, I had seen him going. But then that whole day, playing of whole day is also not contradicted. That stands. Pronita did not say in so many words, but mother's statement that Pronita has told me is also there. It will not go away. And then the photograph part, that will also be taken as a when she went to bring to get the photograph of her son, he was not giving her. And the threatening part is also there. Even after coming out.
To the other witnesses.
Even after coming out from jail, he threatened her to another witness. And his reply to his 313 statement as yes to his confession. His lordship will see question number 60 and 62. As well as 41. Question number 41, 60 and 62. Because the break in the chain that he went back to his house can be somehow covered by the sister-in-law's evidence that he was playing for the whole thing, which is not contradicted. It was not placed before the police. By the mother's death. And the sister-in-law has not denied that she had not stated to the mother.
Okay.
So these are the success.
Your Lordship may kindly see the evidence of PW7 also in this regard, because the PW7, he says he was coming from office, returning from his office at 3:30 p.m. And by that time, police also arrived and dead body was already taken away by the police. So that after 4 p.m., visiting the shop of the accused, that part probably is not
No, 3:30 will be on the next day. 4 p.m. on the previous day.
3:30 on the same.
No, how after body recovered. The body is recovered next day.
PW7.
That
And the
will,
other thing, Lotte, I'm not placing those entire facts. Just I'm to one judgment of Honorable Appellate Court regarding circumstantial evidence.
Citation?
AIR online 2022 Supreme Court 655. Paragraph 45 to 50, Lotte. All the other leading judgments were discussed here, Lotte, including petition. Judgment. Paragraph 45 to 50. Basically, what I find is that the circumstances has to be proved circumstance. That should point the guilt towards of the accused. Here, what my learned friend is pointing out, those only raise a suspicion against the accused.
Okay,
But-
we'll consider.
But-
Heard. Yeah, you heard as an amicus?
Right.
Yes. Going confident, doesn't very good. Okay, we'll consider.
How
okay.
We'll sit at 2:10.
Single.
No, not single. Oh, it is over. Okay. Item 2.
The last order.
Has expired. Has any steps been taken? Not taken. Just a minute. None appears for the petitioner on call, whereas Ms. M.D. Bora, Learned Standing Council Transport Department is present. Para. From the order sits, it reflects that when the matter had come up for consideration on 17/12/2021, this court was informed that the petitioner had passed away in the meantime and time was granted to file substitution petition. Para. The matter was listed thereafter on 9/9/2024 when further 2 weeks time was granted to take necessary steps regarding substitution. Full stop. The matter has been listed thereafter. Today, which is after about 6 months. After more than 6 months. And no steps have yet been taken. Full stop. Para. It appears that the petitioner is not interested in pursuing this case. Full stop. Accordingly, the writ petition is dismissed for want of prosecution. You appear for AG? Arboro. একেলগে হ্যাঁ MD Bora, Transport, Arboro for AG.
Obliged, my lord.
Maybe. Just matter may be passed for the time being.
What is the matter about?
Matter is regarding the stenographer grade 3 lordship. Lordship,
Who is on the other side? CGC, have the CGC will have it after some time. Oh, you are there, CGC. Please inform him. Yes, ask your, tell your senior to come after some time.
Lordship. Number 2.
Two, we have already passed orders. Yes,
Actually, in this case, the petitioner has died.
that we know, that was in 2022.
Yes. Thereafter, I have communicated with the son, but they are not
Hmm.
giving out the required instructions. So I don't know.
Okay, we have closed it.
Lordship. My name
If-
is there.
Then we record your name and we say
Yes,
that we
yes,
do not
yes.
have instruction. None appears for the call na koba, protomote. MH Laskar koba. Sri Laskar
I
has
have
submitted-
instructed them, but they have not.
submitted that in spite of his best efforts,
Yes.
comma, there is no instructions forthcoming for filing substitution application. We'll record that. Oh.
Obliged.
Item 4.
This matter will be passed over for time being. Senior will reprise.
Who?
See, Bora.
Borua.
Case of like case court number 12.
Ms. Sinha for,
Yes, for writ petition or not.
what is the,
There is, my lord, excess royal which has been, which was to be recovered against that, my lord.
you have an interim order? No.
No interim.
Excess recovered already.
No, not recovered. Not recovered.
Then there is no interim order.
Similar, I think I forgot my that interim order maybe there, but
Hmm?
not recovered.
In the meantime, proposed recovery stayed until returnable date.
Yes,
But that has not been
extended.
extended.
The back is not recovered.
After a while then,
Yes.
we'll try. But ask him
State-
to come soon, because if we start the
Yeah, even
election
the
petition,
state, I do not,
we'll not have time. Okay.
state, matlab, I do not know state has filed affidavit or not, madam. The AG has filed.
Okay. Next. Do after a while.
Identify.
Yes.
Fact is like that petitioner applied for the post of statutory assistant in the year 2016. Accordingly, he has passed all the tests, my lord.
Just a minute, just a minute. Sir, why you are appearing?
Lord.
As CGC. What is it?
Lord, applied for the post of statutory assistant.
Laboratory assistant, where?
Yes, in exam rifle recruitment rally held in the year 2015-16. Thereafter, petitioner
15, 16.
Yes.
He applied for laboratory assistant.
Yes. Petitioner passed the all tests into annexer to case 15 physical test. Yes, sir.
You passed what? Physical test.
Oh, yes.
Then
Then my lord, annexer 3 page 17 call letter was issued for written exam.
yes. First you have to undergo physical test.
Yes.
Then if you are qualified, then you have to undergo written
ex-
examination.
Yes.
Then?
Annexer 3 page 17
Yes,
petitioner passed the written examination.
yes.
Then annexer 4 page 18 petitioner passed the detailed medical exam.
Page,
Page 18.
detailed medical.
Yes.
Yes.
Thereafter, annexer 5 page 19 petitioner was for appointed.
Hmm.
Page 9.
Yes. With date.
Date 23/1/2017. Thereafter, my lord, after 2 months, that is from March 1st of March 2017, he was still for military basic training for about 9 months period. My lord, period.
March 2017.
He was still for military basic training.
What is it called? What basic? Military basic training.
Yes. Thereafter, my lord, almost 6 months has completed, my lord. Period is of 9 months, my lord. One incident happened, my lord. My lord, do remember when he was guarding in the family land quarter, my lord, he heard a noise of a girl, my lord.
Oh, yes, yes, yes.
That case. My lord, but my submission is that, my lord, without any inquiry, nothing, they have straight away discharged me, my lord. In my discharge order, they have written on request. That is my case, my lord. Kindly see if you know that, annexer 6, page 20. But my lord, I have never submitted such type of application, my lord. That is my case, my lord.
Page 20.
Yes. Annexer 6.
Date.
Lord, date of discharge on 28 August 2017. Page 20 and annexer 6. In my lord, para number 8, ground for discharge is written on request.
Yes.
That is my case, my lord. I have never submitted any such type of application, my lord. And there is also discrepancy in there. They have in the affidavit, they have said I have submitted one application. But my contention is that in my writ petition also I have categorically said that I have never submitted such type of application. And they have not made any inquiry, my lord. Straightway they have discharged me, showing it.
But
that
what
my-
about the stand in the affidavit that you had indeed
Yes.
submitted an application?
That I have never submitted, my lord, and I have said in my reply also I have given the reply. First of all, my lord, kindly see their affidavit in opposition. Their annexer 1, my lord, page 10. Affidavit in opposition.
Yes.
Page 10, my lord, this is written in Hindi, my lord. And my lord, kindly
This
see
is the discharge application.
application. Date is, my lord, kindly see left hand side, it is 10th August 2017. Right hand side, my lord, signature of the petitioner, Amrit Meet, my lord. But this application I have never, my lord, submitted before the authority. Here date is 10th August.
10th August.
Only my signature was used, my lord. Then, my lord, kindly see next page. There annexer 2, my lord, page 11. Page 11 of their affidavit in opposition, annexer 2, my lord. Here they have said, my lord, kindly see in the, my lord, para 6, para number 6.
Hmm.
that in this regard, I have submitted my resignation application to the concerned authority on 23 August 2017. Here they have written 23 August I have submitted. In the application they have given, it is 10th August. But my contention is that I have never submitted such application and such affidavit also. And my lord, if assuming for a moment, my lord, if I submit the, for a moment, my lord, if I submit that letter, resignation.
Just a minute, just a minute. But this affidavit is before a notary public.
Yes, my lord, that is my, here also, my lord, my signature is given, my lord. This is, my lord, kindly say here they have written, I have filed this affidavit on saying that on 23rd August, I have submitted my resignation.
Yes.
But in annexure 1, my lord, date is 10th August. See the discrepancies, my lord.
No, there is another day, 23 August, down. What is this 23 August 17? On page 10, page 10.
No, this is my lord, recommendation.
Recommendation, I understood, but
This is recommendation. My date, they have said 10th August. Here they have said, and suppose for a moment, my lord, suppose I have submitted 10th August application, 23 August that affidavit, and 28 August they have discharged me. Whether this is the procedure for resignation, my lord. I will get, my lord, 90 days time, they have to, within a period of 90 days, they have to go through a command, my lord, chain of command, my lord. And within a period of, my lord, 1 month, I will get the opportunity of withdrawal. Nothing has been done, my lord. And,
where do you get that period of?
and basic concept.
No, no, that period, where do you get 90 days? Under what
Basic
provision?
concept, my lord, is that, my lord, I have never submitted such type of application.
No, those will be questions of fact. Whether we can go through, therefore you saw the provision of law which requires some minimum period to consider, reconsider.
Yes, my lord, I have some OMs, my lord, and one regulation of Assam People regarding this, my lord. Yes, okay.
Yes, please. It's not in the CCS, CCA.
The CCS, my lord, Rule 26. These OMs are regarding that Rule 26 of.
First, place 26. CCS. এখন ধুনীয়াকে এটা বলো।
And to judgments also, my lord, I have already submitted, wherein it is clearly stated that 90 days period is necessary in FRS.
You're referring to Rule 26.
Yes, 26.
Of what?
26(4), my lord.
No, what? 26(4) of what?
CCS,
pension.
Pension rules, not CCS, pension rule.
See, annexed in my affidavit also.
Okay, just a minute. 26. (26)(4).
Yes.
CCS pension rules, CCS. Please read.
My lord, the appointing authority may permit a person to withdraw his resignation in the public interest on the following condition. Namely, the resignation was tendered by the government servant for some compelling reason, which it did not involve any reflection on his integrity, efficiency, or conduct. During the period of intervening period between the date on which the resignation became effective and the date from which the request for withdrawal was made, the conduct of the person was in no way improper. that the period of absence from duty between the date.
No,
was-
first you have to tell us when the resignation becomes effective.
Yes, my lord.
First show us that under what provision? Within how many days the resignation will become effective?
I think
Now that we have, the pension we have, pension rules we have.
Pension, my lord, retirement date, my lord, 3 months here.
Where, which provision?
FR 56A, my lord, notwithstanding anything contained in this rule, the appropriate authority shall, if it is the opinion that in the public interest so to do, have the absolute right to retain a government servant by giving him notice of not less than 3 months in writing, or 3 months pay and allowances in lieu of that.
FR 56?
They might.
Not applicable logic, where be given without notice terminate.
No, let us submit very.
And my lord-
56. Just a minute, let us,
And one thing, my lord, I was discharged.
just let us first make the note. 56J.
Yes.
Or 3 months pay. Not less than 3 months in writing or 3 months pay.
But every whole thing was done in a period of 15 days. Suppose, it is suppose, my lord, assuming 10th August, suppose affidavit is 23 August, and 28 August I was discharged. Everything, my lord, done illegally, my lord. And my lord, I already said 2 judgments, my lord.
Hmm.
It is just like similar. In those 2 judgments, my lord, they are also in the same way. They have not submitted resignation. And even in application was also submitted in Hindi and signature was taken in English. Same way, my 2 judgments already I have submitted.
Vishwarup Mukherjee,
Yes, that and
Navin Ram
yes, my lord.
of this court.
Yes, this court. Both.
In Vishwarup, which paragraph?
This court, my lord. Lord, last para, my lord, it is my lord allowed. Petitioner was being stated and my lord. Para 12, my lord. 7, 8, or
Para 12,
before that, my lord, only see para 7.
7.
Yes.
Yes.
Petitioner contends that it was not a voluntary resignation, and even it is assumed otherwise, acceptance of resignation was improper without offering counseling to
That
the
is your contention. What is the findings?
finding my lord. Page, my lord, para 18 last page. As a result of the above conclusion, the impugned discharge order was to be unsustainable in law, and same is accordingly
Not the
quashed.
direction, madam. What are the findings on on law? What is required to be done in a case? What is not required to be done?
Then 16, para 16, is it? The case papers made available to the court suggest that counseling was not afforded to the petitioner before his discharge, nor it is reflected that the authorities has applied their mind.
Paragraph
16.
16.
Yes.
Hmm. Okay. And the other one?
Other one also, my lord. WP 56 said nine.
Navin Ram?
Yes, my lord. Here, my lord, relevant paragraph 14, my lord, 1-4.
Para 14.
Yes. If the matter was remanded back, the department acted as was that was said that data
Okay.
is submit these OMs, madam.
Yes. Please first tell us what are the OMs?
So OMs, my lord. Resignation from service.
No, number, date.
Number. Number
Date.
11 February 1988.
OM dated
1988.
on resignation.
Yes.
Paragraph?
Procedure. Para, my lord, 3.
Para 3. And the other one?
And my lord, that is my lord, 10th June 2019. OM withdrawal of resignation of central government
This
servant.
perhaps will not come into operation 2019. Because your incident
yes.
was prior.
17. Then one, my lord, dated 4 December 2007.
4 December 2007.
Yes.
Paragraph?
Yes, my lord. Para 1 and 2 both, my lord. Yeah. Withdrawal of resignation.
Okay, please give copies of first and give all the three will deal.
Regulation of
Regulation regarding?
yes. 105. Resignation and premature voluntary retirement process. Accept.
Regulation, what regulation?
Assam Rifle Regulation 2016.
Okay. Regulation 105. Okay. After this matter, we'll take up the election petition. Others may not be possible. Yes. Now let us finish this first. We'll consider your submission later. Let us finish this first.
Okay.
Wait for a while. Yes. Yes, Mr. Roy?
Okay, regarding giving one counseling Lottie, in our affidavit page 2, we have stated Lottie that on receipt of the affidavit, the commandant personally interviewed the petitioner and once again advised.
Paragraph?
3C.
You had filed an affidavit.
Yes, sir. Please. Reply, they have nothing to say.
No, reply has, but they have not any document matter. They verbal.
Your affidavit is by one Shiva Kumar. Shiva Kumar,
Lottie. Para,
31st of May.
yes, sir. Para 3C. Last that on receipt of the
31st of
affidavit.
May 19. Para 3C, yes.
The commandant personally interviewed the petitioner and once again advised him to withdraw his application and also informed him about the disadvantages of the position of discharge at this stage, but the petitioner did not pay any heed.
What is the reply to this?
Nothing.
Well, I have given reply para 3.
3C,
3 and 3B. Very nice.
3AB is there.
Three C, you have not replied, madam.
Not,
My lord, when the basic,
No, we'll come to it. Have you replied or not?
not.
my lord, as a whole, I have replied.
No. It's not a reply
Para-
to para 3.
Para 3.
You have said you reply to paragraph 3A and 3B. Thereafter, you have come to 3D. It's not against para 3.
I have written that the petitioner specifically submitted that he had never executed an affidavit before. Also contradictory the discharge. However, perhaps we be in the petitioner submitted.
Yes.
They have
Huh?
shown, my lord, that
Anything else?
Produced the original, already I submitted lordship, the original documents are there. Yes.
What about the aspect that 15 days or 30
There
days?
is lordship, there is nothing lordship.
No, FR.
Lordship, that FR is for if we give him a notice, if we discharge him. Here, lordship, he voluntarily comes for it,
Oh, that is not applicable.
not a basic, it's not.
FR 56J is not applicable.
Here, he voluntarily comes for.
voluntary also procedure will be there.
When we gave him a notice, lordship,
Oh,
then
when you
we-
oh, okay. Okay. Okay, we'll consider.
Lord, oblige.
We would have passed the judgment here, but we
Lord.
would like to have the election petition.
Lord.
Maybe good. That's boring. SS for CGC. लेकिन खुदाई नहीं बोलेगी। What are these lot, madam? Now, why have you given this?
Oh, yeah.
No. Petition, some petition. Okay.
Sorry.
Your petition has also come.
Right.
Yes, Mr. Saikya. You'd like to finish your matters? Two matters were passed over for, we'll have some other dates. Mr. Boro? Mr. Boro, we'll have some date. Okay. And the other one, Mr. Sigdar. Where is Sigdar? Yes. We'll have some other date. Today, we have to give reference to election petition.
On the last occasion, I have just started K. Howkeep Hansing versus K.
Yes,
Raikhan
yes.
case,
Yes.
where the issue in my humble submission is totally different. If we go, it's a very short judgment. The relevant paragraph I would like to refer to with the relevant line. Then if Lordship is pleased to take up this matter judgment, 2024 STC online, Supreme Court
Yes,
2548.
we have the copy.
Lordship,
Yes, we have it.
paragraph 2, Lordship. The applicant before the court is a member of Parliament, Legislative Assembly, and was elected from 46 Cycle Assembly constituency in the 12th general election to the Manipur Legislative Assembly, which was held in the year 2022. The respondent, who was also a contestant from the same seat, filed an election petition before the High Court of Manipur challenging the result of the election on the ground that the applicant has not disclosed her assets in the nomination paper and she had indulged in corrupt practices of the election. The applicant filed an application under Order 7, Rule 11 of the CPC with Section 86 of the Representation of People's Act for rejection of the petition, which was dismissed. The application dismissed by the High Court on 5/7/2023 is presently under challenge before this court. The respondent in his election petition inter alia raised the following grounds in challenge. Number 1, because the appellant has declared as the returned successful candidate by improperly accepting the nomination despite the concealment of the asset and investment of rupees 2 crores for land development in the state property of land and construction inside the agricultural land mentioned in her Form 26 affidavit. That is the one ground. The other ground is because the appellant had concealed her total income for the financial year 21-22 and shown ₹0, even though she was serving as committee officer at Secretariat of Manipur Legislative Assembly till 31st December 2021. Before the High Court, the present appellant had moved an application under Order 7 Rule 11 for rejection of the petition on the ground that it does not disclose any cause of action, as it does not specify any corrupt practices alleged to have been committed by the appellant, nor is there any averment regarding concealment of her income assets. Therefore, the election petition does not comply with the requirement of Section 83 of RPA Act and ought to be dismissed at the threshold. Lordship will kindly mark this Section 83. Our case is based on 81. That is one major distinguishing factor. The High Court by the impugn order held that whether the appellant had any income or not and whether he had given a wrong declaration at the time of his nomination needs to be looked into in trial, for which evidence has to be laid by the parties and examined by the court. The petition cannot be dismissed under Order 7 Rule 11 application. Consequently, the application under Order 7 Rule 11 filed by the appellant was dismissed. Aggrieved appellant is now before this honorable court. I'm skipping paragraph 6, now coming to paragraph 7. Before the sub-para before on top of 7. A perusal of the section shows that an election petition should inter alia contain a concise statement of material facts and particulars of any corrupt
You're in
practice.
paragraph?
Sub-para just above paragraph 7.
A perusal.
Yes, a perusal.
Yes.
A perusal of the section shows that an election petition should inter alia contain a concise statement of material facts and particulars of any corrupt practice which is alleged against the returned candidate, etc. Further, the provisions of 83 subsection 1 of the Act requires that the election petition shall be accompanied by an affidavit in prescribed form in support of the allegations of corrupt practice. Over the years, the election petition have been filed invariably on the ground, which are similar to the ones raised before this court. The only question is whether the court can dismiss such a petition at very threshold on an application under Order 7 Rule 11 CPC, or that the petition needs a detailed consideration by the court. The answer to this will depend upon what kind of statutory compliances have been made in the election petition. The case of the present appellant before this court is that if the provision as referred above, wherein material details have to be given by the respondents and particularly the details of corrupt practices, etc., has to be strictly construed, and any deviation by the respondent on this requirement shall make the petition liable to be dismissed at the very threshold. At the same time, this is not what is the requirement of law. Rather, the settled position of law here is that an election petition should not be rejected at the very threshold where there is a substantial compliance of the provisions. Thus, we will have to see whether the substantial compliance of Section 83(1)(a) and 83(1)(b) has been done by the respondent. So, the case before this honorable court is neither on 83(1)(a) nor on 83(1)(b). So, therefore, that issue of substantial compliance will not be relevant so far as present proceeding is concerned. I will place other judgment in response to 81(1), 81(3), which is our case.
Substantial compliance has to be, is it to be understood in the context of 83(1)(a) and 83(1)(b) and not to in case of 86?
86 is one part.
You are absolutely correct in contending that this Waqif's case was revolving around 83(1)(a) and 83(1)(b), whereas
Yes.
in our case, it is 86.
86 read with 81(3).
81(3).
81(3).
Now, the concept of substantial compliance,
Yes.
which has been the main ground
Here.
in this case of consideration, can it be restricted only to the provisions of law which were in that case, or can it be, can it also
Expanded to
extend?
81.
Yes.
Yes.
That on that.
That
we'll
lordship
take-
will definitely consider.
That we like to get,
Yes,
have
but
the
on that
assistance
point, my submission will be very clear. this substantial compliance provision of a particular section, the section which is considered by this honorable court in this Waqif's case,
By the Honorable Supreme Court.
Supreme Court,
Yes,
is section 83, 1A and 1B,
correct.
not on 81(3). Our case is 81(3). 81 subsection 3. And let me finish, then I will give all
Yes.
the distinguishing factors which are relevant for the present adjudication. Now, here, paragraph 8 says, thus we have to see whether substantial compliance of section 83(1)(a) and 83(1)(b) has been done by the respondent. In paragraph 15 of the election petition, the respondent has pleaded that construction worth approximately 2 crores has taken place on agricultural land on the appellant. However, the column for investment in land through construction has been left empty by the appellant. Therefore, the respondent has also pleaded that the appellant was serving as a committee officer of the Assembly Secretariat, Manipur Legislative Assembly till 31/12/2021. Yet she has shown her income for FY 2021-22 as 0 rupees, which is untrue. In paragraph 16 of the election petition, the respondent has referred to section 33 of RPA and alleged non-compliance of the requirement furnishing true and correct information by the candidate. However, in ground day, as reproduced above, it is asserted that since the appellant had concealed her investment of rupees 2 crores in her hand, her nomination paper ought to have been rejected. On a perusal of the petition as a whole and including the averments reproduced above, it is clear that a cause of action has been disclosed by the respondent. Whether the appellant had concealed her investment and her income, thus her nomination has been improperly accepted, is a trialable issue. So what the court has found, Lordship, in my humble submission from the pleadings, it is very clear that a cause of action has arisen, and therefore, regarding the allegations that the income was not properly disclosed, or regarding the other property investment, those can be considered at the stage of trial. Our case is not that. Our case is before trial, the foundation on the basis of which a trial has to be conducted, that foundation is missing. The other Jacob's case and Cyprus case. Now, paragraph 9. Secondly, the affidavit which is required as per the proviso to section 83(1)(c) of RPA has been given in form 25 as per the conduct of election rules 1960, where the rule 94A read as follows. So this is the affidavit format. It's paragraph 10, I'm coming. The affidavit format, it is there, Lordship. A question had come up before a 3-judge bench of this court in GM Siddhestars versus Prasanna Kumar 2013 4 SCC 776 as to whether an election petition is liable to be dismissed at the very threshold, even if the allegations of corrupt practices of a returned candidate have not been given by the petitioner in terms of the provisions of 83(1)(c) of RPA. The finding of this court was that this cannot be done even if an affidavit, the finding of this court was that this cannot be done even if an affidavit is not filed in terms of the proviso. What is mandatory, however, is that there should be a substantial compliance. In other words, if substantial compliance in terms of furnishing all that is required under the law has been given, the petition cannot be summarily dismissed. I rather rely upon this paragraph. What is required to be given under the law has been given. In our case, the signatures, the notary, etc. are not given at all.
You are more on the presentation,
Presentation.
not on the merits.
Not on the merit. Here it is on a different. And our case is that once the election petition is complete in all aspects, then only the process can proceed further, and the Honorable Court may be pleased to frame the issues and send it for trial. Here it has already been there, but certain information is missing. Detailed particulars is not there. Affidavit is done. So in that case, it is a case of substantial compliance in terms of section 83. But my case is totally on a different footing. It is 81. In a more recent case from Manipur, so and so 2023 so and so, this court upheld the dismissal of the returned candidates order 7 rule 11 application by the Manipur High Court in an election petition. The court, after referring to and applying the test laid down in Siddhesor's case, held as follows. The position of law that emerges from the above referred cases is clear. The requirement to file an affidavit under the proviso to section 83(1)(c) is not mandatory. It is sufficient if there is substantial compliance. As the defect is curable, an opportunity may be granted to file the necessary affidavit. So what is here? The application must be accompanied by an affidavit. Which application, Lord? The court's application, not the copy to the respondent. So far as 81 is concerned, they have complied with all the requirements as per the statute, and they have correctly filed it before the Honorable Court. But they are duty bound under 81(3) that identical copies with proper attestation or notarization should be given to the other side, who are party in the case as respondent. The issue of misleading, whether prejudice can be done, whether we are really have to rely and counter and rebut all the allegations of corrupt practice. Here it is only that affidavit is not there. It is at the stage prior to that issuance of notice. So the position of law that emerges from the above referred cases is clear. The requirement to file an affidavit under the provisions of 81(1)(c) is not
83,
mandatory.
83,
Sorry. 83(1)(c) is not mandatory. It is sufficient if there is a substantial compliance. As the defect is curable, an opportunity may be granted to file the necessary affidavit. So that affidavit is not filed along with the petition to the Honorable Court. And the court said that you go and file it. But here it is filed, but not filed, and it has the service copy is not as per the statute. And that is considered in Jacob's case and Supra's case. The law which has been laid down in Siddhesor's case as well as Wakif's case is totally on different factual metrics. The facts are different. Number one, the application before the Meghalaya Manipur High Court is filed under Order 7 Rule 11, read with 86. Now let us see what is 86 for a moment. 86 says, the High Court shall dismiss an election petition which does not comply with the provisions of section 81. That is 81, that petition should be in order and the copies could be equally in order. 82 and 117. Where is 83? Their whole case here is 83(1)(b) and 83(1)(a). 83 is curable. 81 is not curable. The defect, which is a part of the proceedings and in which invocation of section 83 is urged, Lordship, in that case, it is a curable defect. Sipra as well as Jacob said.
And your application is on 86 mainly.
86 read with 81. So therefore, the application before Manipur High Court, considered by my Lord Justice Sudhanshu Tulian, A. Amanullah, was basically on Order 80, Rule 7, Order 7 Rule 11, read with 86. But 86, if we look at it, prima facie, it is not actually revocable, invocable. 86 is not related to 83. It is related to 81 or 82 or section 170. 170 if the court fee is not adequate. 82 is, Lordship, parties to the petition, if the parties are not properly named. And 81 is the presentation of the petition. On 3 different counts. 117, if you look at it, Lordship, security for cost. If Lordship is pleased to have a look at section 117
Yes.
for a moment. 117, security for cost. At the time of presenting an election petition, the petitioner shall deposit in the High Court in accordance with the rules of the High Court a sum of rupees 2,000 as security for the cost of the petition. During the course of the trial of an election petition, the High Court may at any time call upon the petitioner to give such further security for cost as it may direct. So it is regarding the cost. That means court fee. 82, Lordship will kindly see. Parties to the petition. A petitioner shall join as respondent to his petition, where the petitioner, in addition to claiming a declaration that the election of all or any of the returned candidate is void, claims a further declaration that he himself or other candidate may be duly elected, all the contesting candidates other than the petitioner, and where no such further declaration is claimed, all the returned candidates and any other candidate against whom allegation of corrupt practice are made in the petition. So it is regarding the parties who should be implemented. And 81 is, Lordship, I have read it several times, presentation of the petition. In what format, what should be the service copy, etc. Everything is given in presentation. So 86 has to be read with 81, 82 or 117, but never with 83. Contents in the petition. That is why content in the petition. We are fighting a lot of other cases, the same counsel. On the point of, Lordship, that detailed particulars are not given regarding allegations of corruption. I think 2 or 3 cases are pending with my learned senior. In the Purana's court. All these petitions are Order 7, Rule 11. That from the pleadings, no case can be made out because there is no arising of any cause of action.
No, one thing can be perhaps be cleared. So far as 83 is concerned,
Lordship.
the contents of the petition, what you put in the petition, what you not put, that may not be a matter of adjudication as on a preliminary ground.
Lordship.
What can be a matter of adjudication for preliminary ground if you present a petition under 711 or 86 is the presentation of petition. How you present, not the contents.
Not the content.
Not the content. The contents will go to the merits.
Content will cover by 83.
83.
83.
So 83 is not a part of 86.
It is not a part of it.
86 says, but 86 no doubt covers 81 also.
81, 82 and 117.
If you come to 81, yeah, the manner of presentation of petitions.
Yes, presentation of petition.
It also has number 3, 81.3.
81 within bracket 3. Yes.
That means the copies which need to be served upon the other side.
Has to be.
How the copy has to be served.
Exactly.
What are the requirements of that copy?
Lord.
Now, if you come to the aspect of substantive compliance,
yes,
as laid down in Hawkins' case by taking into account the earlier case of Siddheswar, let us see again.
83 is relating to the copy given to the court.
That is the contents of the petition.
Contents of the petition.
Yes.
Our case is 81.3. The copy is given to the respondent.
Yes, that is the part of the presentation of the petition.
Presentation
While you present,
yes,
so far as the copy which is required to be served on the other part, what is that copy is, what manner that copy has to be given. So if you come again to Hawkins' case, the objection, why was it not taken into consideration? Why was it rejected? 3, one size. The objection was connected. Because at what you had also pointed out at paragraph 6, the last paragraph, sub-para, it also talks about 83.1, the requirement of an affidavit.
83.1 will come, Lordship will kindly come to 83.1. the concise statement of the matter, full particulars. And C, 83(1)(C) says,
Yes.
shall be signed by the petitioner and verified in the manner as laid down in Code of Civil Procedure for the verification of treaty. Provided that where the petitioner alleges any corrupt practice, the petition shall be also accompanied by an affidavit in the prescribed form in support of the allegations of such corrupt practice and the particulars thereof. Any schedule or annexure to the petition shall also be signed by the petitioner and verified in the same manner as the petition.
The court had held that it is maybe a curable defect, so you can even put the affidavit on later point of time. So far as 83(1) is concerned.
That defect, Lordship, is in the court's copy,
Court copy.
not the copy given to us. Here, the court copy is perfect.
That is okay, that we have understood.
Lord.
So far as the court's copy is concerned, if the affidavit was not accompanying, that the
Lordship could have, because the same copy would have been given to us also. In that situation, there is no misleading, no prejudice. Because whatever,
here you are alleging that there is a disparity of the copy
yes,
presented to the court and the copy given to you.
yes. CIPRA says that we will get misled. If we go by Justice Bharucha's observation in CIPRA's case, very clearly says that if the affidavit is not in proper format, vis-a-vis the format given to the Honorable Court's copy, that is the original copy, then there is every possibility that we will get prejudice and will get a wrong way. So that distinction is there in CIPRA's case and upheld by the full bench in Jacob's case. Very thin line of difference, Lordship, but that difference is critical and crucial. Our case is 81(3). So in Hawakib's case, Lordship, the copy is given to the Honorable Court and copy is given to the other side. These are identical. Here, the court is properly taken into the process of a trial, whereas the copy given to us is on a different footing and different status. Status is different. And all those reasonings are given in the judgments, these two judgments. The CIPRA's judgment, let me, for a time being, place Bharucha's statement in CIPRA's. Why it is necessary? Paragraph 17 in CIPRA's case, Lordship.
Yes.
May I read it? I am in the respectful agreement with the judgment and order of our learned brother Ramaswamy Justice, would state my reasons briefly. The question that must be posed as indicated by this court's previous decision, does the document purporting to be a true copy of the election petition mislead in a material particular? The true copy of the election petition furnished by the appellant, that is election petitioner, to the respondent, that is successful candidate, did not show the appellant's affidavit supporting his allegation of corrupt practice had been duly sworn or affirmed. Where corrupt practice is alleged, the election petitioner must support the allegations by making an affidavit in the format prescribed. An affidavit must be sworn or affirmed in the manner required by law, or it is not an affidavit. The document purporting to be a true copy of the election petition furnished by the appellant to the respondent give the impression that the appellant's affidavit supporting his allegations of corrupt practice had not been sworn or affirmed, and thus, therefore, no affidavit at all. It mislead a material particular, and its supply was, as the High Court held, fatal to the election. Very clearly, it has been laid down for that it has full possibility of misleading the other side. That means the response. and that observation of Justice Bharucha, paragraph 16 in Jacob's case. Paragraph 16. May I read it?
Just a minute, 16. Yes, paragraph 16.
Yes, paragraph 16. Thus, from the facts noted by Bharucha Justice, it transpired that in Dr. Sipra's case, the true copy of the election petition furnished to the respondent gave an impression that the election petitioner's affidavit supporting his allegation of corrupt practice had not been duly sworn and verified by the election petitioner before the notary, which also had not attested the same, thereby rendering that the document has no affidavit at all in the eye of law. The defect found in the true copy of the affidavit was thus not merely the absence of the name of the notary or his seal and stamp, but a complete absence of notarial endorsement of the verification, as well as absence of an affirmation or oath by the election petitioner. It is in that context that the bench had found in Dr. Sipra's case that the returned candidate would have got the impression, the word impression is there using twice, on the perusal of the true copy of the affidavit that there was no duly sworn and verified affidavit filed in support of the allegations of corrupt practice by the election petitioner. It was precisely on account of this fatal defect that K. Ramaswamy Justice opined that the principle of substantial compliance cannot be accepted in the fact situation. So this lacuna cannot be cured. I'll place other relevant judgments of 1960s also on this point. Therefore, the main distinguishing facts of this Howkipp's case vis-a-vis the case which we have cited and why it is not applicable to our case. Number one, the case was filed under Order 7, Rule 11, read with Section 86 of the RP Act, Lordship. Section 86 does not deal with Section 81. It deals with 82, sorry, it deals with 81, 82, and 117, and
Does
not with
deal with
83. Number two, if we look at 83, it is the content of the petition. So that is what is, there is some shortfall. In the case of Howkipp, that is not the case here. The shortfall is not regarding the pleading. The shortfall in our case is regarding the submission of the affidavit in its proper form, served to the respondent parties. And therefore, if we look at Sipra's case, Jacob's case, and two cases I will be going to place, Lordship, where it is very clearly said the law is well settled and firmly in place as on today that non-furnishing of an affidavit in the petition supplied to the other side, the court copy may be 100% correct. That is not a curable defect, and that is a flaw at the very beginning. And if that flaw is there, it cannot be allowed to be cured. And by considering that it is a non-curable defect, number one, and there is no question of substantial compliance. Within the affidavit, there are two different status. One is that there is absolutely absence of all the requirements to have a verification or affirmation to three authorities, Lordship. In Jacob's case, some leeway is given that if the name or the seal is not there also of the notary, then also it can be considered as substantial compliance. But if there is total absence of the notary or the oath commissioner or the district commissioner before whom it has been prescribed to be notarized or affirmed, in that case, Lordship, if there is total 100% absence of these particular facts or requirements or formalities, Lordship, in that case, it cannot be considered to be a case of substantial compliance. And the fact situation of Howkeep's case and our case is totally different. Our case is that flaw is in the service copy, not in the court's copy. Whereas in this case, the affidavit was not given in the original copy, and therefore the Honorable Court has directed to give it. Because it has to be given to the court as well as to the respondent. So if we see the language of 81(3), may I read it, Lordship?
Yes, please.
Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner in his own signature to be true copy of the petition. So if the true original copy is defective, the same defective copy is given to the other side also. That is the requirement. A defective copy is in both the sides. Then no prejudice will be caused, because we can take that point at the later stage of the case also, at the stage of trial also. But on one hand, one team is getting the full copy, the other side is not getting the identical copy. In that case, it is not a curable defect, and there is no question of having.
This subsection 3 was introduced much later, about a decade. Do you have the objection reasons why it was introduced?
We'll have to find it out, Lordship.
This 3 was not there originally.
Yes,
in the
Lordship, because
51.
yes,
It came in 61 after a
it's
decade.
66, I think.
61. With effect from 66. No, 61.
Lordship, if we see, there is a 2. Small 2 is there.
Small 2 is 61. By
2
act of-
is Act 47 of 1966.
No, that's not 2. That's 1. 2 is inserted by Act 40 of 1961. 1 has been omitted.
1 has been, no, 2 has been omitted, number 4. This will be 5 if I'm not, yes, 5. Yes, Lordship is correct. 9/6/1961.
1961. 29/6.
Objection reasons, Lordship, in the during the course of argument, I'll place it.
Maybe it will throw some light,
I will find it out.
because earlier it was not there, or if it was there, it has been substituted. What
There
was the
must be
reason?
some good reasons.
Mr. Pathak may be aware.
61, the conduct of election rules was
Yes.
and when that debate was going on, the conduct of election rules
Rules came after a decade almost.
after 1961. it came.
61, yes.
So accordingly, the corrupt practice was under section 123. So it was later on stated, since it was a quasi-criminal in nature, corrupt practice quasi-criminal in nature, therefore some stringent provision has to be there. So this additional affidavit, one affidavit is under Order 6 Rule 14, the additional requirement was brought.
In case of corrupt practices,
Corrupt.
then in the
In
prescribed
case-
format.
Because that is,
25, I think.
yes.
Hmm.
I had that copy and it corresponds to 61 conduct of election rule. Corrupt practice you can set aside.
Now, next judgment which I would like to rely is 1974, 4 SCC, page 237, Satyanarayan versus Pujaram and others.
1974, 4 SCC.
4 SCC, page 237,
Satyanarayan.
Satyanarayan.
Paragraph.
The paragraph 8 onwards, I would like to place
Do you have a copy or have you given something?
of the judgment.
Should have given earlier, we could have taken out a copy, madam.
Yeah. If I'm not wrong. it
How
was
many pages?
Very short judgment.
I mean, like,
237 to 247. So 10 pages.
74, 4 SCC. Huh? আজি হে refer কৰিছে, আগতে দিয়া নাই, no?
So we have a copy lot. We are giving. Mark for us. Lordship may take the book. Lord.
Oh, yes, we have. You have already given that. Yes, we have. Assess.
अपने किताब में तो mark for us.
given earlier.
Yes,
It
Lord.
it is there.
So,
Paragraph,
paragraph 8, 3 judges bench, Lordship. Paragraph 8. The short question is whether section 81 subsection 3 of the Act is mandatory, and if so, whether non-compliance of the same will visit the election petitioner with the penalty of dismissal of its petition under section 86(1) of the Act. The question was mooted in Jagat Kishore Prasad Narayan versus Rajendra Kumar Pottar, but the court did not find it necessary to decide the same. Whether a particular provision in a statute is mandatory or directory has to be construed from the scheme and object of the provision. This court observed in Raja Bhulan Sagar case versus Municipal Board, the question whether a particular provision of a statute, which on the face of it appears mandatory in as much as it uses the word shall, as in the present case, is merely directory, cannot be resolved by laying down any general rule and depends upon the facts of each case. And for that purpose, the object of the statute in making the provision is the determining factor. The purpose for which the provision has been made and its nature, the intention of the legislature in making the provision, the serious general inconvenience or injustice to person resulting from whether the provision is read one way or the other, the relation of the particular provision to other provisions dealing with the same subject, and other considerations which may arise on the facts of a particular case, including the language of the provision, have all to be taken into account in arriving at the conclusion whether a particular provision is mandatory or direct. The Privy Council in so and so, the question whether provisions in a statute are directory or imperative has been very frequently arisen in this country, but it has been said that no general rule can be laid down, and that in every case the object of the statute must be looked at. Now, there are two parts in section 81(3). The first part provides that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition. The second part relates to the manner in which such copies shall be attested by the petitioner under his own signature to be true copy of the petition. We are concerned only with the first part of this in this appeal. Part 6 of the Act deals with disputes regarding election. Chapter 2 therein provides for presentation of election petitions, while Chapter 3 for trial of election petitions. The right to challenge an election is conferred under the Act, which is made in conformity with the provisions of Article 329B of the Constitution. It is well settled that it is a special right conferred under a self-contained special law, and the court will have to seek answer to the questions raised within the four corners of the Act, and the powers of the court are circumscribed by its provisions. It is not a common law right, and an election petition cannot be equated with a plaint in a civil suit. We may therefore immediately read the following sections, section 80, 81(1), 81(3), 86(1), which runs as follows. I am not repeating it, Lord. Now, in the same paragraph, section 86(1) refers to three sections, namely section 81, 82, which deals with parties to the petitions, and section 117 of the Act providing for security of cost. While dealing with section 117 of the Act, this court spoke about to one of us in Jagan Mohan Reddy in Saran
this
Lal
you can skip, this you can skip perhaps. Security part you can skip.
Lord. Similarly, in petitions under 82B is considered Lordship, examining the scheme and object of the provision. The provisions of 82B would avoid any such delay, that is the parties.
Yes.
That also I am skipping.
Skipping, please.
13.
Yes.
Keeping in the forefront the proper functioning of democracy, the principal object of the Act is purely of elections. When there for an election of a returned candidate is challenged under the Act, expeditious trial of the election dispute is sought to be enforced by the legislator, making all safeguards against delay. Trial has to be necessarily expedited to read the candidate as well as the constituency interested in the result of the election of any taint or suspicion of corrupt practices, which are again clearly enumerated in the Act. to take therefore another important object of the act, that is expeditious disposal of an election petition by section 86. B. The trial of an election petition shall, so far as practicable, consistently with the interest of justice in respect of the trial, be continued from day to day until its conclusion, unless the High Court finds the adjournment of the trial beyond the following days to be necessary for reasons to be recorded. Again, section 86(7), every election petition shall be tried as expeditiously as possible, and endeavor shall be made to conclude the trial within 6 months from the date on which the election petition is presented to the High Court for trial. Further, 87(1) introduces the civil procedure code only, subject to the provisions of the Act and of any rules made thereunder. Section 87(2) makes a deeming provisions for the application of the Evidence Act only, subject to the Act. Therefore, there is no scope for free play in the application of the provisions of those two acts. The very object of expeditious trial will be defeated if the presentation of the election petitions should be treated casually and lightly, permitting all kinds of devices to delay the ultimate trial. The purpose of enclosing copies of the election petition for all the respondents is to enable quick dispatch of the notices with the content of the allegations for service on the respondents so that there is no delay in the trial at this very initial stage when the election petition is presented. If there is any halt or arrest in progress of the case, the object of the act will get halted, will be completely frustrated. We therefore clearly of the opinion that the first part of the section 81(3), with which we are mainly concerned in this appeal, is a peremptory provisions, and the total non-compliance of the same will entail dismissal of the election petition under section 86 of the Act. So it is a mandatory provision. We are therefore not required to consider the second submission of the Learned Counsel of the with regard to substantial compliance made on the basis of the provisions of 81(3) being directory. We may only add that in the absence of any provisions under Act or rules made thereunder, the High Court rules cannot confer upon the Director of the Deputy or the Deputy Registrar any power to permit correction or removal of defects in an election petition presented in the High Court beyond the period of limitations provided under this Act. Pausing here for a moment, one of the arguments of the other side is that the registry should have found the defect and directed them to clarify. So this is my reply, Lordship. It is not the duty of the registrar or the deputy registrar to give them instructions to get it corrected. We may only add here that in absence of any provisions under the Act or rules made thereunder, the High Court rules cannot confer upon the registrar or the deputy registrar any power to permit correction or removal of defects in an election petition presented in the High Court beyond the period of limitations provided under the Act. It may also be noted that Section 169 of the Act provides that the central government is the authority to make rules under consulting the Election Commission, and in subsection 3 thereof, the rules have to be laid before each House of Parliament in the manner provided therein. The only reference to the High Court rule is found in Section 117 of the Act. At any rate, we do not feel called upon to pass on the High Court rules referred to in the judgment of High Court in this case. In the result, we find no reasons to interfere with the decision of the High Court dismissing the election petition. The appeal is dismissed with cause. Deputy Justice, I agree with my brethren that the requisite copies of the election petition were not filed in the court within the period of limitations by the appellant. I am constrained also to agree that for this procedural fault, this election petition is liable to be dismissed in view of the decision of the court in Jagat Kishore Narayan versus so and so. The case is given there, paragraph 17. It makes me sad to read that this requiem for this election petition over a century ago, a slip in procedure by litigant means denial of justice to him. Right down to the 19th century, the choice of the wrong writ involved the loss of action, even though all the merits were there in the plaintiff. Gradually, however, courts subordinated procedure to the claims of justice in so and so. All rules of courts are nothing but provisions intended to secure proper administration of justice. It is therefore essential that they should be made to serve and be subordinate for that purpose. Speaking in the same vein, Justice Amir Ali said, rules of procedures are not made for the purpose of hindering justice, our decision restored the primacy of the procedure over justice. It makes section 86(1) a tyrannical master. The rigidity of the rule of precedent ties me to this change. My only hope now is that the parliament would make a just choice between the social interest in the supply of copies to the election petitioner, along with his election petition, and the social interest in the purity of election by excluding section 81(3) from the purview of section 81 of the Act. So, if it is there, it has to be followed, and it is a mandatory problem. It has been fortified by a subsequent judgment also.
Satyanarayan. Satyanarayan has been fortified.
This is a case from J&K. The Supreme Court dealt with the J&K local rules, Lordship. And the
What is the
parameter provision
Citation?
citation is Lordship, 1981 SCC page 403. Tariquddin versus Abdul Ghani loan. This judgment, Lordship, 2 paragraphs I have to read out. I would like to read from paragraph 2, Lordship. Not very long judgment.
Yes, please.
Sorry. This appeal is filed under section 123 of the J&K Representation of People's Act 1957. At the general election held in the year 1977 to elect members of the Legislative Assembly of the state of J&K, the appellant and the respondents were candidates for the seat to be filled from Handwara Assembly constituency. The
Mr.
respondent.
Saikia, somebody is disturbing the proceedings. Not fair.
I have done so much for him, Lordship, for last 15 days. Still he is troubling. Maybe he missed the WPL women's final. That may be the reason.
This court was not noticing him, but he made it compulsory that he should be noticed and the proceedings should be disturbed. Reasons are there to be disclosed at the appropriate time.
Lord.
Actually, I am the culprit because I requested him for a certificate, but I was not getting it to see him, to convey my thanks to him.
He is not to be seen. He is
My-
only to be heard.
We'll need an affidavit, Lordship. Proper verified affidavit.
To see him is nowadays it's a privilege.
Yes, of
And to
course.
hear him is even a more privilege.
And he keeps his mobile off. That is the problem.
And we are not seeing him in the corridor also, Lord.
That was not the intention. Yes.
He still think he is in Montessori school. May I continue, Lord?
Yes, please.
So, I am reading paragraph 2. At the general election held in the year 1977 to elect members to the Legislative Assembly of J&K, the appellant
Just
and the...
please clarify this 123 is perimeter.
Yes, Lordship, little bit later, that whole
No,
clarification.
no, just I'll just make a note. 123 of the J&K Act is kept.
89 will be perimeter, Lordship. 80, paragraph 8. Paragraph 8, may I read it from here, Lord?
Yes.
Then. Paragraph 8, the crucial part of 89.3, which is parameter to 81.
89.3.
89.3 of the Act. 89.3 of the J&K
Understood.
is identical to 81.3 of the RP Act of 1951.
89.3 of J&K equivalent to 81.3. Okay.
So, if we replace 81 with 89 with 81, then this case have identical ratio.
Okay, okay.
So, I am coming back to 2.
Yes, please.
The respondents was declared as successful candidate of the returning officer. Thereafter, the appellant filed an election petition before the High Court of JN case challenging the validity of the respondent's election on various grounds. The respondent raised two preliminary objections to the election petition. Number one, that the petition had not been presented in accordance with subsection 1 of section 89 of the Act. And two, that the copy of the election petition had not been attested by the appellant under his own signature to be true copy of the petition as required under section 89(3) of the Act. The respondent contended that the petition was liable to be dismissed in view of section 94 of the Act, which provided that the High Court should dismiss an election petition which did not comply with the provisions of 89 or section 90 or section 125 of the Act. We are not concerned with the first one. I'm skipping now, coming to paragraph 8. The crucial part of section 89(3) of the Act, with which we are concerned, provides that every such copy shall be attested by the petitioner under his own signature to be true copy of the petitioner. And the critical words in this part are under his own signature. The case of the respondent is that the requirement of section 89(3) of the Act, that the copy of the election petition should be attested by the petitioner under his own signature, is a mandatory one. It is his further case that the language of section 89(3) of the Act does not permit of any other mode of compliance, and therefore the attestation made by the counsel for the petitioner filing the election petition is of no compliance of that provision. It is therefore contended by him that the petition is liable to be dismissed as required under section 94 of the Act. Maybe the parameter provision is 86 here. On the other hand, the appellant's case is that since the copies of the petition had been signed by his advocate, who has been empowered to act for him in the case, it should be treated as substantial compliance of section 89(3) of the Act, which having regard to its object must be considered to be directory. The difference between a mandatory rule and directory rule is that the former must be strictly observed. In the case of the latter, the substantial compliance may be sufficient to achieve the object regarding which the rule is enacted. Certain broad propositions which can be deduced from several decisions of courts regarding the rule of construction that should be followed in determining whether a provision of law is directory or mandatory may be summarized thus. The fact that the statute uses the word shall while laying down a duty is not conclusive on the question whether it is a mandatory or a directory provision. In order to find out that true character of the legislation, the court has to ascertain the object which the provision of law is questioned has to subserve, and its design and the context in which it is enacted. If the object of a law is to be defeated by non-compliance with it, it has to be regarded as mandatory. But when a provision of law relates to the performance of any public duty and the invalidation of any act done in disregard of that provision causes serious prejudice to those for whose benefit it is enacted, and at the same time who have no control over the performance of the duty, thus provisions should be treated as directory one. Where, however, a provision of law prescribes that a certain act has to be done in a particular manner by a person in order to acquire a right, and it is coupled with another provision which confer an immunity on another when such an act is not done in that manner, the former has to be regarded as a mandatory one. A procedural rule ordinarily should not be construed as mandatory if the defect in the act done in pursuance of it can be cured by permitting appropriate rectification to be carried out at a subsequent stage, unless by according such permission to rectify the error later on, another rule would be contravened. Whenever a statute prescribes that a particular act is to be done in a particular manner and also lays down that failure to comply with the said requirement leads to a specific consequence. Here, specific consequence is that 86, it will be dismissed. Consequence is written down in section 86. Just for a moment, Lordship, I will
Yes.
86 says, the High Court shall dismiss an election petition. That is the consequence, which does not comply with the provisions of 81 82 or section 170. So this language is very important. It is not it is not a positive, it is a negative. Intention is negative. That this is the consequence you are going to face if you do not comply with 81 or 82 or 170. So the Honorable Supreme Court also very clearly says whenever a statute prescribes that a particular act is to be done in a particular manner and also lays down that failure to comply with the said requirement, that is 81, leads to a specific consequence, that is dismissal. It would be difficult to hold that the requirement is not mandatory and the specific consequence should not follow. So if Lordship allows or holds that 81 is not mandatory, it is directory, then it will dilute section 86. It will get a kind of effect. Therefore, the ratio laid down by several judicial pronouncements as a single direction that this is a mandatory provision. So far as the provision of 83 is concerned, it can be considered as a directory because it can be considered within the realm of substantial compliance and curable defect. But so far as 81 is concerned, Lordship, or to that effect 117, or to that effect, Lordship, 82. These are incurable defects. So, may I read this last line once more? Whenever a statute prescribes that a particular act is to be done in a particular manner and also lays down the failure to comply with that said requirement leads to a specific consequence, it would be difficult to hold that the requirement is not mandatory and the specified consequence should not follow. We now proceed to deal some of the decisions cited as before. Lordship, if Lordship is pleased to look at paragraph 19, it refers to Secretarian's case also. May I read, Lordship, a few lines from paragraph 9, last part, last 5.
Paragraph 19.
Paragraph 19. Lordship will find that Secretarian is in bold. After that, the question whether.
Yes.
Have Lordship got about 10 lines from
Yes.
top. The question whether a provision of law is mandatory or not, as observed already, depends upon its language, the context in which it is enacted, and the subsection 3 of section 89 of the Act provides that a copy of the petitioner shall be attested by the petitioner under his own signature to be true copy of the petition. The emphasis on the above provision appears to be on the words under his own signature. We do not find the same expression used in section 91(1)(c) of the Act, which provides that an election petition shall be signed by the petitioner and verified in the manner laid down in the J&K Code of Civil Procedure for the verification of the pleading. Subsection 3 of section 89 of the Act was inserted by J&K Act of 1962. That means after the 61 amendment in the RP Act. Section 94 of the Act, which requires the High Court to dismiss an election petition. I was submitting that. 94 is parameter to 86. 94 of the Act, which requires the High Court to dismiss an election petition when the petitioner has not complied with the provisions of section 89, was enacted in the place of former section 94 of the Act by J&K Act of 1967 by the legislature with the full knowledge of the requirement of section 89(3) of the Act. The object of requiring the copy of an election petition to be attested by the petitioner under his own signature to be a true copy of the petition appears to be that the petitioner should take full responsibility of its content and that the respondent or the respondent should have in their possession a copy of the petition duly attested under the signature of the petitioner to be the true copy of the petitioner at the earliest possible opportunity to prevent any unauthorized alteration or tampering in the content of the original petition after it is filed into the court. We have no doubt that the records and documents in the custody of the court are taken due care of by the court, and the court would not by themselves give any scope for tampering with them. But still, experience shows, this is the observation of the Honorable Supreme Court, but still experience shows that the allegations are sometimes made that records in the court have been tampered with notwithstanding care and caution taken by the court. Such allegations may not always be without basis. It is probably to obviate any scope for such an allegation being made or to protect the interest of the respondent, the legislature thought of enacting subsection 3 of section 89 of the Act so that the respondents may rely on the copy served on him. When he finds that the original documents in the court contains allegations different from those in the copy in his custody, a respondent would not have the same degree of assurance if a copy served on him is one attested by any person other than the petitioner himself. The attestation by the advocate for the petitioner cannot be treated as equivalent as attestation by the petitioner under his own signature. If the requirement of the second part of section 83(1) that the copy of the petition should contain the signature of the petitioner himself is not one of substance, there is no need to enact it, as the first part of subsection 3 of section 89 of the Act would have been insufficient, for it provides that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and the word copies mentioned therein can only mean true copies. The importance of the provision contained in section 94 of the Act, which makes it obligatory on the part of the High Court to dismiss a petition when it is established that section 89 of the Act has not been complied with, also cannot be overlooked in this context. We are therefore of the view that the requirement that every copy of the election petition which is intended for service on the respondent should be attested by the petitioner under his own signature is a mandatory requirement, and non-compliance with that requirement should result in dismissal of the petition as provided in section 94 of the Act. The High Court was therefore right in dismissing the petition on the above ground. It clearly and squarely covers my case, Lordship. Only thing is that they will say that it is the signature. We are saying the signature is there attested. Only difference, the distinguishing factor which they may raise in their reply. Which
I will not reply to the rejoinder argument.
Yeah, but this is one part regarding the affidavit and the notarization or attestation part. On the other hand, Lordship,
Yes.
the copy which they have served to the Honorable Court, that is the original copy.
Hmm.
There are two components in that copy. One is the pleading part, the other one is the annexure and the schedule.
Yes.
When they gave the copy to us, whether they should write certified to be true copy or attested to be true copy. So they have to attest that it is a copy which is identical to the Honorable Court's copy. Here, if Lordship is to look at the copy which they have served on us, and there are two parts. From page 1 to page 84
Of
Lordship copy as well as our copy.
EP of the election petition.
Election.
Yes.
This is my second limb of argument. Up to page, from 1 to page 84, they have given us attested to be true copy of the petition. Although 3 or 4 pages were missing in between, that will come in my third leg of argument.
Attested?
attested to be true copy of the petition, and there is a signature of the election petition. Here notary part is, I'm not on that. No. So from page 1 to page 84, they have said attested to be true copy of the petition, and lordship will find from page 85 to page 185, certified to be true copy. The other day also, the Jacob and Cyprus case, as well as I'll place one judgment of Karunanidhi and two other judgments, where it has been very clearly laid down by the Honorable Supreme Court that the pleaded part, the affidavit, and all the annexures and the schedule, they all are a composite part of an election.
Yes.
There is no doubt. So when they serve the copy to us, it is required under the law, under the provisions of 81C again, that so not only from page 1 to 84, but from page 85 to 185 also, they should write attested to be true copy of the petition. Because what they have submitted there, if Lordship considers the annexures, the schedule, and the pleadings as one single entity, that is an election petition. So when they are giving that part to us, for Lordship, it is very clear that the annexures are true copies. But when they are giving it to us, it is mandatory on their part to say that it is a attested copy of the petition, where the seal should have been attested to be true copy of the petition. That means the petition is the composite compilation of the dossier filed before the Honorable. The dossier includes the pleadings, the annexures, and the schedules. My problem with Padmadhar Nayak and my learned friend is they have read it several times and they understood very clearly. But they are thinking that I also have understood. So when they write attested to be true copy of the petition for only the pleaded part of the election petition and not the annexures as well as the schedules, then it is defective and it is in violation of section 81 subsection 3. Why? I would like to read once more 81(3). Every election petition, Lordship will kindly mark this word petition, which includes the pleadings, the annexures, and the schedule. So every election petition shall be accompanied by as many copies thereof. Thereof means the petition. As there are respondents mentioned in the petition, and every such copy shall be attested. Every such copy shall be attested by the petitioner under his own signature to be true copy of the petition. Last also of the petition, not of the annexures or the schedule. So when they are submitting that service copy to us, all the pages which there, it is a copy of the original copy furnished to the Honorable Court. They have to write attested to be true copy and not certified to be true copy. They have to say that attested to be the true copy of the petition, which they have rightly done up to page 85. If Lordship is pleased to look at that. From one, if Lordship's copy also, from page 1, it started from the synopsis, the first page, started from District Karimganj, up to the deponent's signature at page 84. On the right hand side, top. Attested to be the true copy of the petition. It is perfectly all right, Lordship. And thereafter, certified to be true copy, court's copy, it is fine because these are enclosures, which we do in normal writ petitions also. But when they serve the copy to us, for the annexers also, they have to write attested to be the true copy of the petition and not certified to be true copy election. No, there is a clause because it is not in alignment with the provisions of 81(3), where the statute specifically prescribes that every election petition shall be accompanied by as many copies, etc. And every such copy, the second part, after N, and every such copy shall be attested by the petition in his own signature to be true copy of the petition. When we say petition, it is the composite of three components: annexer, schedule, and the pleadings. It will not exclude the other two parts. They have excluded other two parts, that is the annexer part and the schedule, as certified to be true copy. What they have to say that it is a attestation to be a true copy of the original petition. So that is the flaw here. And to substantiate this argument, Lordship, I would like to rely upon the judgment of Karunanidhi.
What is the endorsement in the copy served?
Certified to be true copy of the annexer part and the schedule. So far as the pleadings part, identical, Lordship, attested to be the true copy of the petition. Okay. They cannot certify, they have to give attestation. 81(3). At 81(3) says, attested by the petitioner under his own signature to be true copy of the petition. That true copy of the petition is missing. The judgment is, Lordship, 1983 to SCC page 417. Oh, sorry. 473, Lordship. 1983, volume 2, Supreme Court cases, 473, M. Karunanidhi versus Dr. Hande, and there are series of cases decided together. And we have an extra copy also, Lord.
No, you have to have it. It is there.
Paragraph 42,
1983.
page 502.
Para 42.
42. The conclusion is irresistible that the word copies thereof in subsection 3 of section 81 read in the context of subsection 2 of section 83 must necessarily refer not only to the election petition proper, but to schedules and annexures thereto containing particulars of any corrupt practice alleged therein. That being so, we are constrained to reverse the judgment of the High Court in so far as it holds that the photograph of the fancy banner adverted to in paragraph 18b would not be treated to be an integral part of the election petition, but merely a piece of evidence to the nature and type of fancy banner erected by the appellant, and therefore failure to supply a copy of the photograph to the appellant did not amount to violation of the provisions of subsection 3 of section 81. For these reasons, all the appeals and especially so and so. So here, what I am trying to emphasize is that all the annexers, all the schedules are integral part of the election petition. If there is a photograph, there is any document which they want to rely, and therefore, when the word such copy as we found, every such copy, 81.3, this every such copy will include all these three components, and the requirement in law and the statute is every such copy shall be attested by the petitioner under his own signature to be true copy of the petition. I am again stretching upon the word petition, which has found 3 times in that particular provision of 81 subsection 3. Every election petition, one petition, then mentioned in the petition, the second line and the third line, every 3 lines, there is a word petition. And petition, what is a petition? Paragraph 42 of Karunaditi's case. That photograph is also a part of the election petition. And of course, Lordship, the other two judgments, Cipra and Jacob also said, affidavit is an integral part of the petition.
That we have seen.
So when they say true copy, at least certified to be true copy, that will not suffice. That is not in compliance and in sync or in tandem with the provisions of 81.3. It will align with the provisions of 81.3, the requirements and the parameters specified therein. It has to be said that attested to be the true copy of the petition. That petition submitted to them. And that petition, because what they have done from 1 to page 84, they have done it. According to them, the annexures and the schedule are not part of the petition. They did not consider it to be the part of the election. They have segregated. That segregation which they have done, it is not in sync or in compliance of 81.3. There is a violation, there is an infringement. So now another judgment I would like to refer to, Lordship. 1984 3 SCC, page 339. Although the other side is arguing that we should send the matter to the forensic department to find out whether there is any missing page or not. We have very specifically mentioned in our affidavit that certain pages were missing, 4 in number. We have given the page numbers also.
1980.
1984, volume 3 SCC, page 339. Rajendra Singh versus Srimati Usharani and others. Here the issue is 1 page was missing. And I would like to take this honorable court. Paragraph 7 and paragraph 14. Paragraph 14, 15. Paragraph 7, the first part. Here read paragraph 7, 4 lines only. On going to the relevant evidence, we find that there is overwhelming material to show that the appellant did not receive the correct copy, and even the respondent in her evidence did not categorically deny this fact. We have given detailed particulars, which pages we have received, which pages we have received with certified to be true copy at the endorsement, or which copies we have received with attested to be the true copy of the original. We have given all page numbers, and certain pages were missing. And paragraph 5, we have very categorically said paragraph page 11, page 16, page 21, and page 22 have not been served on the applicant. So the election petition which they have served as true copy did not contain 4 specific pages, 11, 16, 21, and 22.
Yes, that we have noted.
Yes. Now, paragraph 14. The
1/4.
main argument on
1/4.
behalf 1/4.
The main argument.
Yes. The main argument on behalf of the remaining appellants was that 11 copies of the election petition were filed on May 10, 1982, and although the copies were served on them, it contained page 17, yet the original copy did not contain page 17, which was thought to be added only by approaching the court of amending the petition. It was further contended that the court had no jurisdiction to accede to the prayer for amendment of the petition, which when at the time of filing the petition, the mandate contained in section 81(3) was not complied with. In other words, the position seemed to be that while the copies which were served on the appellant did contain page 17, yet the original election petition did not contain paragraph 17. This being the admitted position, it could not be said that the copies served on the appellant were the correct and exact copies of the election petition. The provision of section 81(3) is clear and specific and requires every copy of the election petition must be true and exact copy of the petition. The learned counsel for the respondent submitted that this is a highly technical objection and did not cause any prejudice to the appellant because so far as their copies were concerned, they had already contained page 17. In our case, we did not have. We are in a weaker position. Mr. Bhandare, counsel for the appellant, however, submitted that this is beside the point and does not cure the invalidity of election petition filed on May 10, 1982. The mandate contained in section 81(3) enjoins that there should be no difference of any kind whatsoever, bearing some typographical or insignificant omissions between the petition filed and the copy served on the respondent. If an entire page is missing in the petition, but it is there in the copy served on the respondent, then it is manifest that the copy served was not an exact and true copy of the petition. The consequences of the mandatory provisions of 81(3) could not be got over by praying for an amendment of the election petition because that would defeat the very object and purpose of section 81(3). It is not disputed that this discrepancy between the election petition and the copies served on the appellant were undoubtedly there. In serious error of law in allowing the amendment of, in these circumstances, the High Court was wrong and committed a serious error of law in allowing the amendment of the petition. The High Court should have tried to appreciate the tenor and spirit of the mandate contained in section 81(3) of the Act. In the case of Sarifuddin versus Abdul Ghani loan, this court dismissed the petition only on the ground that the word attested to be true copy were not signed by the election petitioner and held that this was not a sufficient compliance of the provisions of section 89(3) of the J&K Representative People's Act, which is the same as section 81(3) of the Act. In the instant case, the inconsistency is much greater than in Sarifuddin's case. Sarifuddin we have placed shortly, and in our case, we are in a much adverse position because we do not have the copy. At least
But
honorable court.
in this case, Rajendra Singh, it appears that in the original copy filed and the copy which was served, there is a discrepancy to that extent that there was an amendment in the election petition.
They sought to amend.
There was an amendment in the election petition, and the amendment was to insert one particular page.
Lordship. That was allowed by the court.
So that amended petition copy along with the page inserted was served on the other side. So how was it held to be inconsistent?
Amended petition was submitted before the honorable court, and the honorable court said that allowed. By the High Court, they have allowed. The Supreme Court said this is not permissible because the mandate of 81(3), you have to do it as per the requirement of 81(3). This is a stringent provision, so there cannot be any dilution of that provision. Otherwise, it will amount to dilute the provisions of 81(3). In that case, the court did not have the copy of that particular page, whereas the respondent have. In our case, the respondent do not have the copy, the Honorable Court has. So in either way, the exact and true copy of the original petition is not identical to the copy served to the respondent. There is a difference. So that difference is highlighted in 81(3), and the mandate of the law is that it is not acceptable, and if that is the case, then it will attract the provisions of 86, which entails dismissal of the election petition at the threshold. A duty cast upon the Honorable High Court to dismiss that kind of defective petition. And in the other cases, I have already tried to place before this Honorable Court that this is not a curable defect. This is not a case where the principles of substantial compliance can be brought in force. So to sum up, Lordship, our case is on 3 grounds. One is that 4 pages were missing,
Yes.
to which the other side is saying that send it to forensic. We again repeat, Lordship, we are agreeing to that proposal. Although they vaguely say that they have supplied full copy, that means without any missing copy. So therefore, it is not only, it's a disputed question of fact, and that cannot be tried. That cannot be an issue at the trial. If they still pursue that, it should be sent to the forensic, whether 4 pages were there part of the petition or not, Lordship. That I am open to it. I am conceding on. Next part is, Lordship, the affidavit, which is very important and critical in case when there is allegations of corrupt practice. That affidavit is without verification or authentication by the 3 authorities, either the notary or the oath commissioner or the magistrate of district magistrate or first class magistrate. There is 3rd authority prescribed. So it was never taken before any such authority. Only the deponent, who is the election petitioner, he put the signature. That is not the mandate, and it will not fulfill the statutory requirement. And in that case, in case of that kind of flaw or shortcomings, Lordship, it is not permissible to the honorable courts also, whether to this honorable court or to the Supreme Court, to direct him to rectify that mistake. The law is well settled from 1966 till date. There is no dilution of that law, which has come to the conclusion that the provisions of 81(3) is either a curable defect or substantial compliance will suffice. The law laid down in Howkeep's case is regarding substantial compliance, but that was in a different context. That was a petition under Order 7, Rule 11, read with 86, wherein the pleadings were not sufficient to make any cause of action for trial. So they sought dismissal of the petition on the ground that no cause of action has arisen from the pleadings, details were not there. So that was the ground. Although they have said that this is a petition under Order 7, Rule 11, read with Section 86, but if you look at the language and the mandate and the requirements and the prescriptions of 86. 86 does not have any control or any relevance if there is any violation of the provisions of section 83. 86 says only about non-compliance of 81, 82. 81 is the presentation of the petition. 82 is the parties to the petition read with, or alternatively 117, which is the court fee. So 86 does not have any alignment with section 83. So that Aukip's case is on the factual matrix of 83. So the law laid down therein that substantial compliance part is not applicable to a case where there is the allegation of violation of section 81. I am urging that there is violation of 81 not only on account of the verification part or the affidavit part, but also regarding the certification or attestation of the petition filed to the honorable court. That is whether the petition, the copy which is served on the respondent should have the endorsement as attestation to be true copy of the petition, or whether certified to be true copy will suffice. There is a distinction I am trying to emphasize before this honorable court that attestation to be true copy of the petition has a different connotation, different meaning. Certified to be a true copy of the petition is a different meaning. The mandate is attestation number 1, which is found very in clear terms without any ambiguity in the language and meaning of 81(3). When 81(3), the second part very clearly says that the supplied copy, every such copy, that means the supplied copy shall be attested, not certified. Attestation and certification are two different things. So shall be attested by the petitioner under his own signature to be true copy of the petition. Here they have said certified to be true copy. Certified to be true copy this is a very vague term so far as election petition is concerned. Certified to be a true copy of what? Question mark. It can be the document, it can be the statute, it can be the petition. That is the pleading part. But from page 1 to 84, I have done it correctly. From 85 onwards to 185, they have said certified to be true copy. But certified to be true copy of what? That they have not indicated. That will also not be sufficient. They have to say attested to be the true copy of the petition, which they have not done. And that vital mistake is not curable in my humble submission, neither it is be considered as a case of substantial compliance, because the law is very strict and stringent that if they do not follow the mandate of section 81(3), the easiest and shortest route for the Honorable High Court is to give a dismissal order in favor of the respondent to the adverse or to the detriment of the petitioner or the election petition. High Court will not allow the court case to proceed on such defective foundation to send the case for trial on some issues which have social and political and civil consequences. And amendment is also not permissible in the factual matrix. The law laid down in Cyprus case is a good law as it is held in Jacob's case. In Cyprus case, all the affidavits were devoid or it was in absence of any attestation or notarization. In Jacob's case, there is authorization or attestation, but the name and seal of the notary officer was missing. So in that case, the Honorable Court said that it is a case of substantial compliance. That means notary has been done, attestation has been done. The detailed address of the notary officer was not given. So in that case, the full bench or the constitution bench opines that it can be considered as a case of substantial compliance because as the notary is there, whereas the court's copy had everything. In our case, that formality relating to notarization or attestation before a officer prescribed under the law is totally missed. So in that view of the matter, and the Honorable Supreme Court itself, in the Constitution bench itself, has found that the law laid down with the factual matrix of Cyprus case. 4 cases were decided in Cyprus case, 4 civil appeals. All had identical effects. And the Honorable Supreme Court said that in that factual context, the law laid down in Cyprus case is correct law. And they themselves has distinguished. I don't have to do it. In 2-3 paragraphs, the different factual metrics were analyzed and opinion is given. And till date, Cyprus is a good law, Jacobs is a good law, and law laid down in Karunanidhi and all the cases which I have faced or it, there is no overruling of those propositions in law. In that view of the matter, in my humble submission, this is a fit case for this honorable court to invoke the authority given under Section 86 of the Representation of Peoples Act 1951, which states that when there is non-compliance of the provisions of 81(3), then the only course open before the honorable court is to give a dismissal order in limine without going for any trial. So that is my humble submission. But again, I am submitting, if they want forensic test, I am agreeing. This is my humble submission.
I'm not submitting anything. Only one thing. I have given my compilation in the form of bullet point along the argument and also the compilation of judgment. If your lordship kindly in exercise of power under order 18 rule 3A, director is to keep it on. Order 18 3A.
Only one thing, Lordship, although it has been argued that they have done substantial compliance, in what manner? That is also quite vague. Substantial compliance, at least not 100%, at least some percentage has to be complied regarding attestation or regarding notarization. Till now, there is nothing on record that they went to the notary office was closed. Anything of that sort also has not come. So there is no question of giving them any handle on the principle of compliance substantial.
Okay.
Deeply humble, Lordship, and obliged.
Heard 3D secure learning sine council assisted by so. Also heard 3 KB Pathak learning sine council assisted by so. ऊपर से देख लूंगा applicant return candidate on KB Pathak for election opposite party election petitioner. The hearing on this application is concluded and the orders are reserved.
Tip top.
Your application for what?
Application, Lordship, the Election Commission is approaching this honorable court only for a very limited purpose to intervene and for the release of ballot units, Your Lordship.
You have an intervening application?
Yes, Your Lord.
That we can allow? That not but you yourself have got out of the petition.
Yes, Your Lordship, because as under Section 82, the Election Commission of India cannot be a party. So that is why under that ground.
Cannot be a party. Why are you trying to intervene?
Lordship, only for the release of the ballot units. And Your Lordship, there is a.
When are the elections?
Elections are in
Ballot
next year,
units,
2026.
Votes counted became more than the votes polled.
No, but Your Lordship, all I'm asking is for the release of the ballot units and the votes.
When are the elections?
It's in February 2026, but before that, there is a lot of compliance that needs to be undertaken.
How many machines are there?
3,326.
Machines.
EVM machines that has been stored. And what happens, your lordship, the FLC, the first level checking, etc., is going to start very soon. Before that, this ballot unit, actually the entire EVM machines need to go to ECL, which is the Electric Corporation India Limited in Hyderabad.
What do you say?
So for intervention is concerned, I have nothing to
No,
say.
no, to secure.
But for the
we do not
application,
know what,
I need to file objection. They are referring to a handbook. He holds the notification issued under Article.
We can do one thing, we can issue notice in our application,
My lord.
at least one step forward.
And I can file my
We don't
objection
know
within 2 weeks.
which side will decide.
Yes.
If we decide in one side, it may not be necessary. If we decide in the other side, it may be necessary.
My lord.
In the meantime, you can file your,
Within 2 weeks time, within 2 weeks time, we'll file.
and the
our-
other side, return candidate to their application.
They will not object, I think.
Below.
No, you can file your,
No, we want a fair play. If it is required to be kept,
no, you can give your opinion by way of an affidavit.
we'll
You
file
can
it.
support them, you can oppose them, whatever.
Right.
Where is your application, madam?
Lordship, I-
Intervention confirm.
Okay.
Intervention confirm.
Application, the intervention application is that's application number 461 of 2025.
Asaniki,
IA 461 of 2025
461.
of 2025 is the intervention application. Actually, while numbering, the number became, then the other application is 460.
Okay. Heard, Ms. P. Barrow, learned counsel for the applicant, who by means of this application made under order 1 rule 80, read with section 151 of the CPC, has prayed for a permission to intervene in the election petition. Full stop. It may, however, be mentioned that the election in the election petition, which was presented, comma, the Election Commission of India and its officers were made parties, and the Election Commission of India had filed IA number ... for striking off. And such prayer was allowed by this court by order dated 28/8/2024. Under such condition, comma, it has to be examined as to whether the petition itself would be maintainable. Full stop. Para. Be that as it may, let notice be issued, returnable by 4 weeks. Who are parties here? Three. M. Datta, learned counsel, appearing for the opposite party number 1. And I have learned counsel accepts notice on behalf of the respondent number 1, whereas your name, S.K. Talukdar, learned counsel accepts notice on behalf of the opposite party number 2. Full stop. By the returnable date, comma, response may be filed by the opposite parties.
Lordship, so the other application is 460, which is for the release of ballot units. Both the applications may be taken together.
No, first you have to examine your intervening. If we
Okay,
dismiss
okay,
your
sir.
intervening, you cannot grant you any prayer.
Obliged. Sir. Fine, sir.
I'm obliged.
Obliged. Sir.